ಗಾಟ್ ಇಟ್ ಅನ್ಬೇಕಾದ್ರೆ ಏನೆಲ್ಲ ಯಾಕೆ ಬಂತು
First, VT submission. VT submission memo
ಸರ್ ಸ್ಯಾಮ್ಸಂಗ್ ಅಂತ ಅಪಿಯರ್ ಆಗ್ತಾರೋ ದಯವಿಟ್ಟು ನೇಮ್ ಹಾಕಿ. ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇದೆಯಾ?
ವಿಶ್ವೇಶ್ವರಯ್ಯ ಅಂತ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 3.
ನೇಮ್ ಹಾಕಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ವಿಶ್ವೇಶ್ವರಯ್ಯ.
ನೇಮ್ ಹಾಕಿ.
ವಿಶ್ವೇಶ್ವರಯ್ಯ ಬಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಆರ್ಡರ್ಸ್.
In mentioning through video.
Serial number 3, my lord.
Serial number
3.
Make a mention
Order.
the matter reaches.
Okay,
Yes. Any memos from the left side? Quick, please.
moving memo for to consider suspension of sentence.
What offense?
138
Monday.
conviction against 138.
Yes. Next.
The trial court has been acquitted. Sessions court has been acquitted. Past year.
Yes. Monday. Take it Monday.
Lord, this is a suspicion of the sentence now 138 section 138 offense, my lord. Today the police are approaching the petitioner to the arrest, my lord. Madam
Yeah.
posted end of the
See. Yes. Yes, Tuesday. Yes.
Institution granted, provincial was granted. The extension of maintenance that Sessions Court had ordered 20,000 has taken into stay. Very posted and extended.
They have taken interim stay.
Yeah, taken.
You have taken interim stay. What is the urgency then when you have taken
My
stay?
lord, even cause we have to collect. My lord, the trial court has not.
According to you, you have obtained stay.
Yes.
Then what is the urgency?
My lord, it was only granted for 4 weeks, my lord. It was granted on 3/9, my lord, last night.
Hmm.
Tuesday was only granted for 4 weeks.
Huh.
So as
Was
of
it
now,
not
stay-
listed thereafter? Did you not move for an extension of stay?
We had movement on vacation to the staff. So we have-
Tuesday. Yes.
My lord, I for suspension of sentence under section 138.
Tuesday. Yes.
You had responded for admission. The petitioner
Yes,
has
we
taken,
did. Yes.
section 374, that is the conviction.
Hmm. No urgency. Yes. Any mentionings? Yes.
Nothing on behalf of the petitioner, my lord.
Yes.
Counsel on record is not feeling well, my lord. Speech and maybe I will come next week, my lord.
We'll see when the matter reaches. There is an early hearing application. Yes. Next. Yes.
Take up next week, my lord.
Tomorrow. 10 years old matter. A short accommodation as paid is granted. List this matter on 1910 on the top of the list. Yes. 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 Yes.
Senior department. As per 2 serial number
32.
32.
32.
Yes, sir.
At the request of the learned counsel for the petitioner, to which time as paid is granted. Yes.
Serial number 35.
Yes. Next matter. 30. Yes. It's same. 2 weeks. Yes. Call the cases. Yes.
That's file I joined from
Learned counsel, whom you appear for.
responding.
Learned counsel for the respondent submits that the matter is being settled between the parties in a civil suit. As such, for quoting the infructuousness of the petition, he prays for a week's accommodation. The time as paid is granted. Yes.
Serial number 35. Advocate on record is not there. Serial number 35.
Yes. Call the cases.
Non-compliance of office objection first time, serial number 1, B. Vachan.
Petition number. What is passed in the trial?
Is it maintainable? Whether revision is maintainable?
Not the dismissal order, my lord.
No, I am not to clarify you whether it is maintainable or not. I am only asking you whether it is maintainable. If you insist that it is maintainable, tomorrow, if it is proved that it is not maintainable, you will lose the limitation, if any, in another petition.
I understand what my lord is.
Yes.
I submit this, my lord. The reason why I filed this revision petition, my lord, is that the stage of the PCR, when there is a delay, my lord, in the filing of the PCR, under section office at 138, my lord. Since there is a delay, there is a notice issued. It was not served. I did not take fresh steps. The things that PCR was dismissed prior to the appearance of the application. That's the reason I filed this.
I'm not asking what the fact is.
Please, my lord.
I know what the fact is. I'm just asking you if you say maintainable, I will hear you regarding maintainability. You are not convincing me on the point of law regarding maintainability. You are telling what the fact is.
I request my lord to have it on Wednesday.
At the request of the learned counsel for the petitioner, a week's time as paid is granted. List this matter on 1910.
Serial number 2, Hegde Ramakrishna S.
Magistrate court passed the judgment under section
No.
12 of DA.
Are you sure it is maintainable?
397 CRPC, the court may entertain the petition. 401 also.
Then you may lose the, say, the liberty to file any other petition on the limitation.
I may be permitted to file a memo.
You are playing with the court then. Pass it over. I pass a detailed order.
Serial number 3, B. Vishwesvaraya.
My lord, 2 weeks time, my lord, for compliance of office objection.
3 to 9. 1 week to comply.
Serial number 10, second time.
None appears finally 1 week. Yes.
It's an objection. The objection is serial number 2 regarding the address of the party. We have disputed the source of the notice in that address. That address given of the petition is wrong. The address mentioned in the affidavit is the right address. That wrong we have tried.
Is there a place called Madanaki in Kundapur? Is it not Madamaki?
The address of the petitioner is Gandhinagar Post, Chara, every Karnataka. It's still in the affidavit.
No, the office objection, is it not with respect to the address of the respondent here?
Petitioner.
Impugned judgment shows one address. In the cost title, you have shown your address differently. In your affidavit, they have given one more address, right?
The address of the judgment and the petition is the same, but the actual address is stated in the affidavit. So you challenge on that.
Then that actual address you have not mentioned in the cost title. In the cost title, you have given different address than what is shown in your affidavit.
We have stated as in the judgment of the.
You have not shown what is there in the judgment also, right? In the judgment it is Hebri village, Karkala Taluk. You have shown in the cost title as Madanaki, Kundapur Taluk. ನೀವೇ ಸರಿ ನೋಡ್ಕೊಂಡು ಬರಲ್ಲ ಕ್ಯಾಶುವಲ್ ಆಗಿ ಏನೋ ಹೇಳೋದು ಕೋರ್ಟ್ ಎದುರು. The learned counsel who is appearing for the petitioner appears that he himself is not clear as to what the office objection is. On the other hand, even according to him, there is discrepancy in the address of the petitioner shown in the memorandum of revision petition to that of the impugned judgment passed in criminal appeal and to that of the sworn affidavit filed by the petitioner herein. In view of the same, matter could not be proceeded. However, for wasting the time of the court without being properly prepared to make the submission, a fine of ₹500 is imposed upon the petitioner payable to the Legal Services Committee of this court within a day from today, and filing a complaints memo along with receipt in the registry to that effect. List the matter on 1810.
Number 12, Sandesh Kumar M.
I will compare the one week accommodation. Complaints.
As finally, 1 week time is granted at the request of the counsel for petition.
Fourth time, serial number 13, Rudramurthy GT.
None appear for the petitioner either physically or through video conference. A perusal of the order sheet would go to show that in spite of granting several and sufficient opportunities of not less than 4 times, the petitioner has not complied the office objection. Even after granting time as finally, still one more adjournment was granted, even in the absence of the learned counsel for the petitioner, to enable him to comply of his objection. In spite of the same, the petitioner has neither complied with the office objection nor shown any reason for non-compliance of office objection. Hence, the petition stands dismissed for non-compliance of office objection as well as for non-prosecution.
Still number 14, Kumara.
None appear in this matter either physically or through video conference.
Number 14.
In spite of granting several and sufficient opportunities, the petitioner has neither complied with the office objections nor shown any reasons for non-compliance. Not less than 4 opportunities were given to the petitioner to comply office objection. Still, he has not complied with the office objection for more than 1 year, 8 months now. Hence, the petition stands dismissed for non-compliance of office objection and for non-prosecution.
Still number 15, fifth time, Raja Srinivas A.
None appear for petitioner either physically or through video conference. On 10/10/2022, this court had made the following observation. In spite of the above, the petitioner has neither complied with office objection nor shown any reasons for non-compliance of office objection, despite getting 5 opportunities to comply office objection. Hence, the petition stands dismissed for non-compliance of office objection as well as for non-prosecution.
Orders matter. Still number 16, Kumar L. K. M. Krishnappa.
I'm appearing for the respondent. I didn't ask to remind that. I mean,
Learned counsel for the petitioner not present. Learned counsel for the respondent alone present. As finally 2 days time is granted to the petitioner to file the amended memorandum of petition, filing which the court may proceed to pass appropriate order in this bold matter of the year 2030. List the matter on 18/10.
Still number 17, Nehru MN. Kenneth Maray Anand Perez, correspondent.
the office of section the affidavit along with the IFO with all of the 3% amount.
Counsel for the respondent submits that office objections are complied with on IE. Resist it to verify and proceed further.
Still number 18, Vijay Krishna Bhatt.
For the respondent, place for a short accommodation too, which time is specified.
Still hearing on interlocutor application, still number 19, Uday Prakash M. Mohammed Nias for respondent.
Withdrawal of 50% amount allowed. Transactions between, yes, paid the loan amount of 7 lakh rupees in the year 2003, my lord.
138 proceedings.
Yes, my lord. 138 proceedings.
Confirmation of conviction.
Yes, my lord. Please.
Application is bereft of the detail as to what is the quantum of the amount deposited and when. Those two are very essential details which are required to give. You cannot merely put an omnibus clause. Whatever amount deposited by order of the court be ordered to be released. Cannot be.
Put as ordered by 50%.
Your application should say how much of amount is deposited and on what day. Both the details are not there available in the application. File a fresh application. There are counsel from both sides present. After hearing the submission on A1/22, it is noticed that the said application is bereft of the necessary detail as to the quantum of the amount alleged to have been deposited and the date of the deposital of the amount, and also the detail of the court where the said amount is said to have been deposited. As such, the said application doesn't deserve to be proceeded further, doesn't deserve to be allowed. Accordingly, reserving liberty to the applicant to file a fresh application. IA1/22 stands disposed of as rejected. Stands rejected. Same order.
Seal number 20, Prabhakar M. A. Vijay Kumar Bhatt, correspondent.
Time to file objections. Request week's time. File objections to them.
Counsel for respondent alone present in place for a week's time to file his objection to IA1/22. The time as paid is granted.
Seal number 21, Dharmapal D. Bhuvaneshwari, correspondent.
Counsel for the respondent present and none other appears on the both sides. Yes.
Seal number 21, Dharmapal D. Bhuvaneshwari, correspondent.
The parties are present. That will matter. The amount of 2,50,000 about the matter for 2,07,000.
Who are the parties?
Mr. Vedgopal, petitioner. Regional.
How you got the graded cost? You are for accused, right?
I am for the.
Yes, he has to pay 37,500 rupees to the court as graded cost. That was told to you the previous date of hearing.
Fine has been.
The graded cost has to be paid. That is totally different head.
The extra 2,50,000 will check amount. Reduce some.
Neither I reduce nor I increase. If you insist, I may increase, but not reduction. Yes, get the graded cost, and it appears there is some mistake in your application. If you don't rectify that, then other side may be at a trouble in withdrawing the amount in the trial court.
The date has not.
Why should I tell you? Look yourself. Yes.
My application is not let them withdraw the amount.
You have accepted that you would withdraw. Why did you sign that compromise petition? Signing compromise petition on different terms and making different submission. Where does it carry you? You shouldn't have signed the compromise petition. You should have asked him, withdraw that amount and pay that money, or any other condition which you wanted to put, but you have agreed. You yourself have agreed. You signed it. Shall I pass over the matter? Would you bring graded cost? $230. Yes, ascertain whose name the DD has to be brought and get a demand draw. Learned counsels and parties from both sides as identified by the respective learned counsels are physically present.
5,000.
That is fine amount that goes to the state. That is not adjustable. Learned counsel for the petitioner prays for a passover of the matter to enable the petitioner to bring a demand draft towards the graded cost of the sum of ₹37,500. Accordingly, the matter stands passover. Call of 2:30 p.m. Yes.
Seal number 22, Ram T. Nagaraj M for respondent.
Present previous of the party is present. ಲೋಕದಲ್ಲಿ ಮಾತಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸಂಸ್ಥೆ ಆಲ್ರೆಡಿ ಕಂಪೇರ್ ಸೆಟಲ್ಮೆಂಟ್ ಮೇಲೆ ಮಾಡಿರೋ ಅಮೌಂಟ್ ಹೇಳಿದ್ರೆ ಅದನ್ನ ಕೊಡ್ತೀವಿ ಅಂದಿರೋದನ್ನ 4 months ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿಬಿಟ್ಟು proceedings current pending
ಎಷ್ಟು ಫೈನ್ ಅಮೌಂಟ್?
9 lakh,
ಚೆಕ್ ಅಮೌಂಟ್
7 lakh.
If it is settled, report the settlement here itself under 147.
Please, ma'am.
Yes, we will dispose of. Shall I pass over the matter? Settlement ಎಲ್ಲ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಬನ್ನಿ 147 ಅಪ್ಲಿಕೇಶನ್ ತಗೊಂಡ್ಬನ್ನಿ. Right now we will settle the matter.
4 months time is
ಅವ್ರು ನಾಟ್ ರೆಡಿ ಅಂತಿದ್ದಾರೆ ನೋಡಿ. ಎಷ್ಟು ಅಗಲ ಅವರು ಕುತ್ತಿಗೆ ಅಲ್ಲಾಡಿಸಿದ್ದಾರೆ ಹೀಗೆ ಅಂತ 180 ಡಿಗ್ರಿ.
4 ತಿಂಗಳು ಅಂತ ಅಂದ್ರು ನಾವು ಅಷ್ಟಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಒಂದು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 1 ತಿಂಗಳು ಒಳಗಡೆ ಕೊಡಿ ಅಂತ ಈಗ ಅದನ್ನೇ ಹೇಳ್ಬಿಟ್ಟು ಹೊರಗಡೆ ಬಂದಿತ್ತು.
ನೋಡಿ
ತುಂಬಾ ಲಾಂಗ್ ಆದ್ರೆ ಈಗ ಆಗ್ಲೇ ಸುಮಾರು ವರ್ಷಗಳಾಗಿದೆ. Even
ನೋಡಿ. 6 ವರ್ಷ ಆಗಿದೆ. 6 years old matter.
violated the order of this court. That's why stay was also vacated.
Vacated. NBW ತಗೊಂಡು ಬರ್ತಾರೆ ಮನೆ ಹತ್ರ ಅವ್ರ ಪ್ರಕಾರ.
Even liberty was given, ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ತಗೊಂಡು ಮೂವ್ ಮಾಡ್ಲಿಲ್ಲ. ನಾವು ಹೇಳಿದ್ದಾರೆ ಅಂದ್ಬಿಟ್ಟು ನಾವು ಸುಮ್ಮನೆ ಆದ್ವಿ.
ನೋಡಿ ಅಷ್ಟೆಲ್ಲ ಕಾಲಾವಕಾಶ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಿದ್ದಾರೆ. ಅಷ್ಟೆಲ್ಲ ಕಾಲಾವಕಾಶ ಕೊಟ್ರ ಮೇಲೆ ಮತ್ತೆ ಫರ್ದರ್ ಕಾಲಾವಕಾಶ ಇಲ್ಲ ಸ್ವಾಮಿ. ದೀಪಾವಳಿಯಲ್ಲಿ ಬಲಿ ಒಳಗೆ ಹೋದಾಗ ನಾವು ಅವರನ್ನು ಒಳಗಡೆ ಕಳಿಸುವ ಮಾವನ ಮನೆಗೆ ಅಂತಿದ್ದಾರೆ. ಏನ್ ಹೇಳ್ತೀರಿ? ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತಾರಲ್ರಿ.
ತಿಂಗಳು ಅಂತ ಹೇಳಿದ್ವಿ. ಈಗ ಅದನ್ನೇ ಹೊರಗಡೆ 4 ತಿಂಗಳು ಅಂತ ಕೇಳಿದ್ರು. 1 ತಿಂಗಳಲ್ಲಿ ಅಂತ ಅಂದ್ರೆ ಅವ್ರೇನೋ 3 ಲಕ್ಷ 1 ತಿಂಗಳಲ್ಲಿ ಕೊಡ್ತೀನಿ, ಇನ್ನೊಂದ್ ತಿಂಗಳು ಟೈಮ್ 3 months ಟೈಮ್ ಕೊಡ್ತಾರೆ.
ಅದು ಮಾತಾಡ್ಕೊಳ್ಳೋದು ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಳೋದು. ಅವರು 1 ತಿಂಗಳು ಅಂತ ಹೇಳಿದ್ದೇನೆ. ಆ ಹೇಳಿದ ಅವಧಿಯು ಮುಗಿತಾ ಬಂತು ಅಂತಾನೆ ಹೇಳ್ತಿದ್ದಾರೆ ನೋಡಿ ಅವರು. ಈಗ ರಿಸ್ಕ್ ನಿಮ್ಮ ಮೇಲಿದೆ. ರಿಸ್ಕ್ ನಿಮ್ಮ ಮೇಲಿದೆ ಅಲ್ವೇ? ಈಗ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇಲ್ಲ. ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ ಅವರು ಯಾವುದೇ ಸಮಯದಲ್ಲಿ ಬೇಲಿಫ್ ನ ಕರ್ಕೊಂಡು ವಾರೆಂಟ್ ತಗೊಂಡು ಬರ್ಬೋದು ಅವ್ರ ಹತ್ರ. ಹಾಗೇನಾದ್ರು ಬಂತು ಅಂತಾದ್ರೆ ಅವಾಗ ಬಹಳ ಅನಾನುಕೂಲತೆ ಉಂಟಾಗುತ್ತೆ. ಅದ್ರ ಬದಲು ಏನೋ ಹೊಂದಾಣಿಕೆ ಮಾಡಿ ಅವ್ರನ್ನೇ ಏನೋ ಕೇಳ್ಕೊಂಡು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಉತ್ತಮ. ಅವ್ರು ಹೂ ಅಂದ್ರೆ ಕೊಡೋಣಂತೆ. ನೀವು ಅವ್ರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ. ಅಲ್ರಿ 1 month ಟೈಮ್ ಕೊಡೋದು. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಮ್ಯಾಟರ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆ 1 month ಟೈಮ್ ಅಂತ ಹೇಳಿದಾರೆ. ಹಂಗಾಗಿ 15 days ಟೈಮ್ ಕೊಡಿ. ಆಮೇಲೆ 15 days ಬಂದಾಗ ಮತ್ತೆ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ನೆಗೋಸಿಯೇಷನ್, ಆಮೇಲೆ ಮತ್ತೆ ಅಡ್ಜರ್ಮೆಂಟಿಗೆ ಎಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋ ಟೈಮು. ಕಾಂಪ್ರಮೈಸ್ ನಲ್ಲಿ 1 month ಟೈಮು. ಈಗ ನೀವು ಸಬ್ಸ್ಟಾನ್ಶಿಯಲ್ ಅಮೌಂಟ್ 3 ಲಕ್ಷ ಏನೋ ಈಗ ಕೊಡ್ಬೇಕು,
3 ಲಕ್ಷ ಕೊಡ್ತೀವಿ.
ಉಳಿದಿದ್ದನ್ನ ಆನಂತರ ಕೊಡ್ಬೇಕು 1 month ಟೈಮ್ ನೊಳಗೆ. ಅದು ಅವ್ರ ಟರ್ಮ್. ಅಡ್ಜರ್ಮೆಂಟ್ ಅಲ್ಲ 1 month. ಅದ್ ನೀವುಂಟು ಅವ್ರು ನನಗೇನ್ ಗೊತ್ತು, ನೀವಿಬ್ರು ಇದ್ದೀರಿ, ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ. ನಾನು ಹೀಗೆ ಹೇಳಿದ್ದಾರೆ ಅಂತ ನಾನು ಹೇಳಲ್ಲ, ಹೇಳಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳಲ್ಲ. ಐ ಆಮ್ ನಾಟ್ ಸಪೋಸ್ ಟು. ಮಾತಾಡ್ಕೊಳ್ಳಿದ್ರೆ ನಿಮಗಿಬ್ಬರಿಗೆ ಗೊತ್ತು. ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲರ ಕೇಸ್ ಮುಂದುವರಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಅದಾಲತ್ತಿಗೆ ರೆಫರ್ ಮಾಡಲ್ಲ, ಇಲ್ಲೇ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ. 147 ಯಾರಿದ್ದಾರೆ? ಸುರೇಶ್ ಬಂದಿದ್ದಾರೇನ್ರಿ? ಕರೆಸ್ರಿ ಈ ಕಡೆ ಮುಂದೆ. ಎಲ್ಲಿ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಎಲ್ಲಿ? ಅವರಲ್ಲ, ಅವ್ರು ಬರ್ಬೇಕು. ನೀವು ಉಮಾಶ್ರೀ ಅಲ್ರಿ? ಏನಂತ ಮಾತುಕತೆ ಆಗಿದೆ ನೋಡಿ. ಹೆಂಡತಿಯರ ಹೆಸರಿನಲ್ಲಿ ವ್ಯವಹಾರಗಳನ್ನ ನೀವು ಹಾಗೆಲ್ಲ ಮಾಡಬಾರ್ದು. ಧೈರ್ಯ ಇದ್ರೆ ನಿಮ್ಮ ಹೆಸರಿನಲ್ಲಿ ಮಾಡ್ಬೇಕು, ಅಥವಾ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ತಗೊಂಡು ಮಾಡ್ಬೇಕು. ಗೊತ್ತಿಲ್ಲದೆ ಇರೋರನ್ನ ಮನೆಯಲ್ಲಿ ಬಿಟ್ಟು, ಅವ್ರಿಗೆ ಏನು ವಿಷಯ ಗೊತ್ತಿರಲ್ಲ, ವ್ಯವಹಾರಗಳು ಗೊತ್ತಿರಲ್ಲ, ನೀವು ಗಂಡಂದ್ರುಗಳು ಇದಕ್ಕೆ ಸೈನ್ ಹಾಕು, ಇದಕ್ಕೆ ಹಿಂಗ್ ಮಾಡು, ನಾನು ಹೇಳ್ದಷ್ಟು ಮಾಡು ಅಂತ ಮಾಡ್ಕೊಂಡು ನೀವು ವ್ಯವಹಾರಗಳನ್ನ ಮಾಡಬಾರ್ದು. ನಾಳೆ ಪೊಲೀಸ್ನವ್ರು ಮನೆ ಬಾಗ್ಲಿಗೆ ಬಂದ್ರೆ ಮರ್ಯಾದೆ ಹೋಗೋದು ನಿಮ್ಮ ಶ್ರೀಮತಿ ಅವರದು. ಅವಾಗ ಪೊಲೀಸರು ನಿಮ್ಮನ್ನ ಮಾತಾಡ್ಸಲ್ಲ. ವಾರಂಟ್ ಬಂದಿದೆ ಅಂತ ಹೇಳಿ ಉಮಾಶ್ರೀ ಅವ್ರನ್ನ, ನಿಮ್ಮ ಶ್ರೀಮತಿ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ನೀವು ಮಾಡೋ ತಪ್ಪಿಗೆ ಅವರಿಗೆ ಯಾಕಿದೆ ಅನಾನುಕೂಲತೆ? ಗಂಡ ಅಂತ ಹಾಕೊಳ್ಳೋ ನನಗೆ ಇಷ್ಟ ಬಂದಿದ್ದು ಎಲ್ಲದೂ ಮಾಡೋದು ಇದೆ ಅಂತ ಅನ್ಕೊಳ್ಬೇಡಿ. ಕಾನೂನಲ್ಲಿ ಅದಕ್ಕೊಂದು ವಿಧಿ ವಿಧಾನಗಳು ಇದ್ದಾವೆ. ಈಗ ನೋಡಿ, ಆ ಹೆಣ್ಮಗಳಿಗೆ ಪಾಪ ಏನು ಗೊತ್ತಿದೆಯೋ ಇಲ್ವೋ ಇದೆಲ್ಲ ಏನಾಗಿದೆ ಅಂತ. ನಾಳೆ ಅವ್ರು ಪೊಲೀಸನ್ನ ಕರ್ಕೊಂಡು ಹೋದ್ರೆ ಮರ್ಯಾದೆ ಹೋಗದೆ ಯಾರು? ಜೈಲಿಗೆ ಹೋಗದೆ ಯಾರು? ನಿಮ್ಮ ಮನೆಯವರು. ನೀವು ಮಾಡೋ ತಪ್ಪಿಗೆ ಅವ್ರನ್ನ ಕಳಿಸ್ತೀರಿ. ಏನ್ರಿ ಮಾತುಕತೆ ಆಗಿದೆ ಸೆಟಲ್ಮೆಂಟ್ ಇಂದು? ಯಾವಾಗ ಹೇಳಿದ್ದದು? ಈಗ ನೋಡಿ. ಈಗ ಜಸ್ಟ್ ಹೊರಗಡೆ ಮಾತಾಡಿದ್ದನ್ನು ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ. Just no settlement. Proceed on the merit. We will hear.
Next week or wife ಕರ್ಸಿ amount
ಬೇಡ,
ಇಲ್ಲ
ವೈಫ್ ಅನ್ನು ಕರ್ಸಿ ಏನ್ ಹೇಳ್ತಾರೆ? ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಿರ್ತದೆ?
ಇವರು ಅಮೌಂಟ್ ಕೊಡ್ತೀವಿ.
Counsel from both sides present. Though both sides submit that the parties have arrived at a settlement, but learned counsel for the petitioner submits that there is some differences regarding the term of the settlement, about the time to be granted for the payment of the entire amount. This he prays for a week's accommodation. As finally, a week's time is granted either to report the settlement or to proceed further in the matter on its merit.
ಫ್ರೈಡೆಗೆ ಹಾಕೊಡಿ, ಅಷ್ಟೊಳಗಡೆ ಜಾಯಿಂಟ್ ಮೆಮೊ ರೆಡಿ ಆಯ್ತು ಅಂದ್ರೆ ಫೈಲ್
ಕೇಳಿ, ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆಗುತ್ತೆ ಅಂತ. ಒಂದು ವಾರ ಕೇಳ್ತಿದ್ದಾರೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ ತಾರೀಕು ಬೇಕಿಬ್ಬರಿಗೂ?
19
this matter on 19/10/2022 as paid. 19ನೇ ತಾರೀಕಿಗೆ ಏನಿದೆ ರೆಡಿಯಾಗಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗೋದಾದ್ರೆ 147 ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್. ನೀವೇನು ಹೋಗ್ಕೊಳ್ತೀರಿ ಮಾತುಕತೆಗೆ, ಅವರಿಗೆ ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ಅದು ಗೊತ್ತಿಲ್ಲ ಇದು ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಬೇಡಿ. ಅವ್ರ ಕೋರ್ಟಿಗೆ 1,05,000 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕಾಗತ್ತೆ, ಪಾರ್ಟಿ ಕೊಡೋದಲ್ಲದೆ. ಅದು ಆ ಲೈಬಿಲಿಟಿನೂ ಅವರಿಗೆ ಹೇಳಿ. Is the matter on 19/10/2022. Yes.
Serial number 23.
The parties were also made known about the liability of the accused to pay the graded cost as per Damodar Prabhu's case. In case the matter is settled under section 147 of NIA case.
Serial number 23. Shivraja M. M.R. Balakrishna, correspondent.
None appeared in this matter either physically or through video conference. The perusal of the petition would go to show that the present revision petition is of the year 2019, which in turn had arisen from a criminal case of the year 2013, as such 9 years old matter. Next line, though this petition was filed on 1st February 2019 till 4th November 2019, the petitioner failed to comply the office objections raised by the registrar. Even after passing a peremptory order on 15/10/2019, the petitioner has failed to comply the office objection, which led this court to pass an order of dismissal of this petition for non-compliance of office objection on 4/11/2009. Next line. Seeking recalling of the said order of dismissal, the petitioner, though filed IA 1/2020, however, that was also with a delay of 153 days. Seeking condonation of said delay, no doubt the petitioner has filed IA 2/2022, but the IAs were also with certain objections. Even today, the petitioner, learned counsel for the petitioner has learned. Even today also, the learned counsel for the petitioner has not appeared in this matter. As such, no further proceeding could be taken place, including issuance of notice upon those IAs. This clearly go to show that the petitioner is not interested in prosecuting this matter and not even interested in getting the orders on its merit on the pending IAs.
My lordship, I'm with the
Where
petitioner.
the petition was dismissed for
My-
non-compliance of office objection. Hence, the matter once again stands dismissed for non-prosecution. Non-prosecution, yes.
I am representing the respondent.
Next
my
line.
lord. My presence may be rotated.
Yes,
Respondent
next, not
complies.
necessary, you have come now, yes.
Yes.
Number 24, Satish M. Dodamani.
None appear for petition. Making it clear that in case the petitioner, in case the learned counsel for the petitioner fails to appear on the next date of hearing, the court may proceed to pass appropriate order as a last opportunity. A short accommodation is granted, list the matter on 1910.
Till number 25, Rachana L. Party GS correspondent.
Dismissed and dismissed again. Again.
23 matter once again stand dismissed ಅಂತ ಬಂದಿದೆ. Hence matter once again stand dismissed for non.
None appear, hence the matter could not be proceeded.
Serial number 26, Satyanarayan Chalke.
Yes. That is party's fate. If the party attracts such a risk, what you can do as a counsel? Let it suffer it. ಎಲ್ಲ ಆಗ್ತದೆ. ನಮ್ಮಲ್ಲಿ ಕಾಯಿಲೆ ಬರುವವರು ಸಾಯೋರು ಇನ್ಎಬಿಲಿಟಿ ಆ ಸಂಖ್ಯೆಗಳೇ ಜಾಸ್ತಿ ಕೆಲಸ ಮಾಡಬೇಕು ಅಂತ. ಇದರಲ್ಲಿ ಪಾರ್ಟಿ ಬರುವ ಯಾವ ಅವಶ್ಯಕತೆ ಇರಲಿಲ್ಲ. ಇಂಡೆಕ್ಸ್ ಟು ಬಿ ಸೈನ್ಡ್ ಅಂಡ್ ಡೇಟೆಡ್ ನೀವು ಮಾಡಬೇಕಾಗಿದ್ದು ನಿಮ್ಮ ಪಾರ್ಟಿ ಅಲ್ಲ. ಇಂಡೆಕ್ಸ್ ಫಾರಮ್ ಇಸ್ ಟು ಬಿ ಫಿಲ್ಡ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಪೇಜಿನೇಷನ್ ನೀವು ಮಾಡಬೇಕಾಗಿದ್ದು ನಿಮ್ಮ ಪಾರ್ಟಿ ಅಲ್ಲ. ಹಾಗಾಗಿ ಪಾರ್ಟಿ ಹುಷಾರಿಲ್ಲ ಅನ್ಲಿಕ್ಕೂ ನೀವು ಪೇಜಿನೇಷನ್ ಮಾಡದೇ ಇರೋದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಹಾಗಾಗಿ ಎಲ್ಲದರಲ್ಲೂ ಪಾರ್ಟಿಗಳು ತಲೆಗೆ ಕಟ್ಟಬೇಡಿ. ವಕೀಲರು ಮಾಡುವುದು ಫಸ್ಟ್ ಮಾಡಬೇಕು. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಮ್ಯಾಟರ್. ಮ್ಯಾಟರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಹೌದು, 20,000 ಕಟ್ಟಿ 20,000 rupees ಕಟ್ಟಿ. ಈಗ ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಡ್ತೇನೆ, 2 days ಟೈಮ್ ಕೊಡ್ತೇನೆ. ಚೆಕ್ ಅಮೌಂಟ್ ಹೆವಿ ಇದೆ ರೀ, ಚೆಕ್ ಅಮೌಂಟ್ ಹೆವಿ ಇದೆ. ಈ ಪಾರ್ಟಿಯ ಇಂಥ ಸಿಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಗಳನ್ನು ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲಿಲ್ಲ. ಅಷ್ಟು ಸಾಲದು ನಂಗೆ ಪಾರ್ಟಿ ಹುಷಾರಿಲ್ಲ ಇನ್ನೊಂದೇನು ಅಂತ ಹೇಳ್ತೀರಿ. ನೀವು ಮಾಡೋ ಕೆಲಸಕ್ಕೆ ಬೆರಳನ್ನು ತೋರಿಸ್ತೀರಿ. 20,000 ಕಡಿಮೆ. ಯಾಕೆಂದ್ರೆ ಇಲ್ಲಿ ಪ್ರಾಮಾಣಿಕತೆಯ ಕೊರತೆ ಇದೆ. ನೀವು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಸ್ವಾಮಿ ನಾನೇ ಮಾಡ್ಬೇಕಿತ್ತು ಕೆಲವೊಂದು, ನಾನೇ ನನ್ನ ಇನ್ನೊಬ್ಬರ ಕಂಟ್ಲೆತ್ತು ಇನ್ಯಾವುದೋ ರೀಸನ್ ಅಲ್ಲಿ ನಾನೇನು ಮಾಡ್ಲಿಲ್ಲ, ನನ್ ತಪ್ಪಿಂದ ಪಾರ್ಟಿ ಸಫರ್ ಆಗ್ಬಾರ್ದು, ಏನೋ ಸ್ವಲ್ಪ ನಾಮಿನಲ್ ಕಾಸ್ಟ್ ಹಾಕಿ ಮಾಡಿ ಅಂದ್ರೆ ನಾ ಕನ್ಸಿಡರಬಲಿ ಕಡಿಮೆ ಮಾಡ್ತೀನಿ. ನೀವು ಅದನ್ನ ಹೇಳಲಿಲ್ವೇ? ನೀವು ಅದನ್ನ ಹೇಳಲಿಲ್ಲ. ಅಡ್ಮಿಟ್ ಮಾಡೋದ್ರಲ್ಲಿ ಅರ್ಥ ಇಲ್ಲ. 10 ಕರೆದು ಔತಣ ಕರೆಸ್ಕೊಂಡ್ರು ಅಂತ ಗಾದೆ ಇದೆ ಕನ್ನಡದಲ್ಲಿ. Right now, 5,000 ಕಟ್ತೀರಿ. I will permit you to comply office objection, but I will not recall the order unless you comply the office objection within 3 days. Or the submission of the counsel for the petition. Though the office objections which were yet to be complied at the time of dismissal of this petition for non-compliance were simple in nature, like signing of the index page and filing of the index form according to pagination. The learned counsel, the petitioner attempted to show that due to the lack of communication with the petitioner, he could not comply. Those simple office objection could have been complied with by the learned counsel himself without anticipating any instruction from his client, since the petitioner had nothing to do regarding the signing of index by his learned counsel and pagination of the case. However, considering the request made by the learned counsel for the petition, pending consideration of IA 1/22, pending consideration of IA 1/21, the petitioner is permitted to comply all office objections after depositing a cost of ₹5,000 in favor of the Legal Services Committee of this court during the course of the day, and filing a complaints memo along with receipt in the registry during the course of the day, subject to payment of the said cost. The petitioner is permitted to comply office objection in total within 3 days from today. The petitioner shall be permitted to comply office objection only after satisfying the payment of the cost order today. In case the cost is not paid, the benefit of today's order would not inure to the benefit of the petition. This is the matter on 21/10.
Number 27, Kalpana P. Suvarna S for R1 to R3.
Of this court will file application to this application. Though I would not have filed application to this application, the circumstances which they are filing application has to be approved. What a time. Despite suffering this adverse order, they filed application in a matrimonial divorce case, filed similar application as to end order by suppressing the proceeding and also the pending petition for this court. Therefore, I have to apply. What is this?
This is a wife's petition, right?
Rights petition.
Learned counsel from both sides present. At the request of the learned counsel for the respondent, a week's time is granted to file their objection if any via 1/22. List the matter on 20/10.
Number 28, Hiramat Siddhalingaya, Charanaya, B.O. Chandrasekhar for respondent.
Our copy put it here. Application is filed by them. You appear for? You are for petitioner. Then your place is here. Learned counsel for the petitioner alone present. Learned counsel for the respondent not present. Have you filed your objection to the IA?
No,
You have no objection.
yes, I will file objection. I will file objection.
You are already granted with sufficient time. You are granted with sufficient time already. It was made clear to you on the previous occasion that no further time would be granted. Yes. Since in spite of granting sufficient time, the petitioner has not filed his objection to IA 1/22, it is taken that objection to the said IA has not been filed. It's a matter in the week of the next to hear on IA 1/22.
Number 29, Mohan Chandra P. Nagaratma, respondent, served.
You are passing an order or making a request?
Stay on. 20% deposit have been put on trial court already.
What is your name?
Puttiregowda. Puttiregowda.
Serial number 29.
Sorry.
None appearance the matter could not proceed. Okay.
Serial number 30.
Respondent for
138 proceeding.
release of the amount. I have supplied material worth 45 lakhs.
No, you are the petitioner.
I am the petitioner.
I will make that.
And the entire.
You have filed the application. ಹೀಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಹೀಗೆ ಎಳಿಬೇಕಾಗ್ತದೆ. ಈ ಪಾರ್ಟಿ ಬೇಜವಾಬ್ದಾರಿ ಇರ್ತಾನೆ ಇದ್ರಾಗ ಹೇಗೆ ಅವರಿಗೆ ತಪ್ಪು ಮಾಡೋದು ನಾವು ಸ್ಟ್ಯಾಪ್ಲರ್ ಕೊಡೋದು. how much of the amount is deposited and when it was deposited?
Lord,
And in which-
I brought it, other further.
Very big. Better application. Current counsel from both sides present. Current counsel for the respondent applicant in IA 1/22. That would not press IA 1/22. However, with liberty to file fresh application with all necessary details. Reserving him the said liberty, IA 1/22 stands disposed of as not pressed.
Because 13 years
ನೀವು ನಾಳೆನೇ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ಬೇಡ ಅನ್ನಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತ ನಾನೇನ್ ಹೇಳಿಲ್ಲ. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾಳೆನೇ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡ್ರು ತೊಂದರೆ ಇಲ್ಲ. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರಿ ಅವ್ರಿಗೆ ಒಂದು ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಬಿಡಬೇಡಿ. ನಿಮ್ಮನೆಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಊಟ ಗೀಟ ಎಲ್ಲ ಕೊಡಿ, ಕಾಫಿ ಕೊಡಿ, ಅಪ್ಲಿಕೇಶನ್ ರೆಡಿ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್ ಒಂದು ಚಿನ್ನದ ಹರಿವಾಣದಲ್ಲಿ ಇಟ್ಟು ಕೊಟ್ಟು ಕಳಿಸಿ.
Serial number 31, Leeladhar HP, SPP third.
Delay of 119 days. But not aware about being of the disposal of the fee. Thereafter, the supply copy. As some of the copies have been handed over. Subsequently, some of the copies.
ಕಕ್ಷಿದಾರಗಳು ಹೇಗೆ ಹೇಳ್ತಾರೆ ಐ ವಾಸ್ ನಾಟ್ ಅವೇ ಅಂತ? ಆಶ್ಚರ್ಯ ಇರೋದಲ್ಲಿ ಬೇಲ್ ಬೇಕು. ಒಂದು ಸರ್ತಿ ಬೇಲ್ ಸಿಕ್ಕ ಮೇಲೆ ಅವರೇ ಹಾಕಿರೋ ಕೇಸ್ ಏನಾಯ್ತು ಅಂತ ಅವ್ರಿಗೆ ಬೇಡ. ಐ ವಾಸ್ ನಾಟ್ ಅವೇ ಅದನ್ನ ಧೈರ್ಯವಾಗಿ ವಕೀಲರ ಮೂಲಕ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹೇಳಿಸ್ತಾರೆ. ಅವ್ರಂಗ್ ಹೇಳಿದ್ರು ನೀವು ಅವ್ರ ಕಿವಿ ಹಿಂಡಿ ಹೇಳ್ಬೇಕು, ಅಯ್ಯ ಐ ವಾಸ್ ನಾಟ್ ಅವೇರ್ ಅಂತ ಹೇಳಿ. ನಾನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಕೋರ್ಟ್ ನೀವು ವಕೀಲರೇನ್ರಿ ಅಂತ ನಮ್ಮನ್ ಕೇಳುತ್ತೆ. ಅವೆಲ್ಲ ಕಾರಣಗಳು ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನೀನ್ ಎಷ್ಟೇ ಅನಕ್ಷರಸ್ಥ ಆಗ್ಲಿ ಬಡವ ಆಗಿರ್ಲಿ ಇಂಥ ತಿಳುವಳಿಕೆ ಇರಬೇಕು. ನೀನಾಗಿ ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದೀನಿ, ನಿನ್ ಕೇಸ್ ಏನಾಗಿದೆ ಅಂತ ನೀನು ತಿಳ್ಕೊಳ್ಬೇಕು. ಐ ವಾಸ್ ನಾಟ್ ಅವೇರ್ ಅಂತ ನೀನ್ ಹೇಳಿದಾಗ ನಾನ್ ಹೇಳಿದ್ರೆ ಕೋರ್ಟ್ ನನ್ ಮೇಲೆ ನಗುತ್ತೆ ಅಂತ ಲೀಲಾಧರ್ ಅವರು ಕಕ್ಷಿದಾರನಿಗೆ ಹೇಳ್ಬೇಕು. ಮತ್ತೆ
ಏನಾಯ್ತು ಅಂದ್ರೆ ಲಾಕ್ಡೌನ್
ಆ ಸುಳುಗಳು ಬೇರೆ ಹೇಳಿ ಕೇಳೋಣಂತೆ. ಆದ್ರೆ ಐ ವಾಸ್ ನಾಟ್ ಅವೇರ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀರಿ?
And some of the documents obtained in December 2021.
ಬೇಡ, ಕೋವಿಡ್ಗಳು ಮರ್ಯಾದೆ ಅಲ್ಲಿಗೆಲ್ಲ ತೆಗೆಯೋದು ಬೇಡ. ನಾವು ಮರ್ಯಾದೆ ತೆಗೆದು 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 ಕೋವಿಡ್ಗೆ ಬೇಜಾರಾಗಿ ಬಿಟ್ಟಿದೆ.
I agree with that. Level properties in a mark ಆಗಲಿಲ್ಲ. Properties claims to have been got released by the PW1, claiming that her property. Those properties not produced for the court as for ID. Except photograph. Property na court ಅಲ್ಲಿ ಐಡೆಂಟಿಫೈ ಮಾಡದೆ ಹೋಗು.
You were accused number 2.
Yes, sir.
But you have shown yourself as accused number 1.
Accused number 1 is
You have shown yourself as accused number 1 in the cause title, right?
yes.
ಯಾಕೆ ಅದು?
Extremely sorry. I'm extremely sorry.
Accused number 1 ಏನಾದ್ರು appeal ಹಾಕಿದಾರೇನ್ರಿ? Information ಇಲ್ಲ. ಎಲ್ಲ ಕಂಡಕ್ಟ್ ಮಾಡಬಹುದೇ?
With regard to the delay on my oral submission, kindly the reasons assigned in para 3 of the affidavits. My oral objection will be the 3 of the affidavit accompanying the application. Order passed on 26/11. On that day, he doesn't know about the passing of the order. Subsequently, he came to know on 27/11, subsequent date, and got the certified copy on 4/12. However, the reason assigned in the subsequent para 4, 5, 6 are not commensurate with the reason mentioned in para 3. That is my interest.
You have been served with the notice or advance copy.
Sir,
The counsel for the petition is physically present for his submission. Issue notice to the respondents both on the main appeal and on pending IAS. Learned HCGP, who is physically present, accept notice for respondent and submits that advance copy of the memorandum of petition along with IAS have already been served upon them. He submits his oral objections to pending IAS. Heard both sides. IA 1/22 and 2/22. Perused IAS on the impugned judgment and also the grounds raised in the memorandum of provision petition. IA 1/22 is filed. Section 5 of Limitation Act seeking condonation of delay of 115 days in filing this revision petition. Concerning the reasons shown in the affidavit accompanying the application, also the nature of the petition. The IA 1/22 stands allowed and the delay of 115 days in filing the appeal stands condoned. Are you on bail throughout?
yes, sir.
He is on bail. Learned counsel from both sides submit that either to the present petitioner, that is accused number 2, is on bail, and that the terms of the bail have not been violated by the present petitioner. In the such circumstances, I am of the view that imposing reasonable conditions. ಇನ್ನೊಂದು ಅಯ್ಯ ಎಲ್ಲಿ ಮರಿ ಹಾಕುತ್ತೇನ್ರಿ ಬೇಕಂದ್ರೆ IA 2/22 filed under section 397 of CRPC is allowed and the petitioner is enlarged on bail during pendency of this revision petition. However, subject to the conditions that format ಇದೆ ಹಾಕಿ executing a personal bond for a sum of ₹40,000 along with a surety for the like sum to the satisfaction of the registrar judicial of this court. To inform the court in writing about the change in address CPN under acknowledgement. To be abide by the orders that would be followed in this matter. To appear before the court as and when summoned. Format ಇದೆ ಕಂಡೀಷನ್ಸ್ ಇದ್ರೆ ಬೇರೆದಿದ್ರೆ ಅದನ್ನು ನೋಡಿ ಹಾಕಿ. The above conditions to be complied with within 10 days from today. Call for PCR and SCR.
This matter seal number 34, Balkrishna MR, R. Srinivas for respondent.
The petitioner and respondent
Some 34.
have settled the matter. Perfect the settlement. The petitioner has paid a sum of 8 lakhs to the
You appear for petitioner.
petitioner, my
Ah.
respondent, towards full and final sum.
Settle the matter.
Yes, my lord.
If they have settled the
This
matter,
is my
then you withdraw this
instruction.
petition.
This is my instruction, my lord.
Then you can withdraw this petition as not first.
Petitioner responded their both relatives.
Maybe that is
Yes,
fine. So if they have
Pursuant
settled
to
the
the-
matter, that is really a good thing.
Total fine amount is 10 lakhs, and in pursuant to the settlement, the petitioner had paid a sum of 8 lakhs, was full and final sum.
That is fine. Then what do you want to do now in this matter? If they have settled,
Yes.
how do you like to proceed further? Do you
The-
want to withdraw this petition or what do you want to do?
The respondent has to come and make necessary submission before this on court.
Not necessary if you are withdrawing the petition.
Yes, I will get the instruction and I will file necessary application within 1 or 2 days. 2 days time I will grant.
Learned counsel for the petitioner who physically present submits that the parties have settled the matter amicably as such. He requests 2 days time to file necessary application in the matter. Two days time is granted, list the matter on 1810.
Number 35, Sharda C. N. Subhash Shastri, for respondent.
1810, list the matter on 1810. Either to report the settlement in accordance with law under section 147 NI Act or to proceed further in the matter on its merit. Yes. Yes. Counsel for the petitioner not present, like counsel for respondent alone present, as such the matter could not be proceeded. Yes.
Serial number 36, R.P. Deshpande, K.H. Pradeep Kumar, for respondent.
Was it part heard earlier?
Yes, sir. Petitioner ಗೆ notice ಕೊಡ್ತೀವಿ ಅಂತ. It's also true. Petitioner.
Settlement I can read out of Indian, out of continental. ಹೌದು ಆಮೇಲೆ ರಿಲೀಸು ಆಯ್ತು. ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ಗೂ ಗೊತ್ತಿಲ್ವೇ? ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ಗೂ ಕಾಂಟ್ಯಾಕ್ಟ್ ಇಲ್ವೇ ಅವರು? ಹಾ ಹಾ ಅವ್ರ ಇಮೇಲ್ ಐ ಡಿ ಅಂತದೇನಿಲ್ಲ ನಿಮ್ಮ ಹತ್ರ? ಅದೇ ನಿಮಗೆ ಅವರು ಇಮೇಲ್ ಐ ಡಿ ಕೊಟ್ಟಿಲ್ಲ. Learned counsel from both sides present. The counsel for the petitioner submits that his attempt to contact the petitioner, who was resident of Mumbai, has went in futile. The letter written to him on the registered post has also returned unserved, changing that the addressee has left the address. He submits that he is attempting to get his present address if possible, for which he requires a short accommodation, to which time has reduced.
Number 37, we are Balraj, SN Mahesh, correspondent.
None appear. That is possible.
Number 39, Putire Goda.
I am. Lawyer Kotli, 20% deposited. The completion of deposit the 20% amount before the trial for serial number 161-21-22, roll number 2363 dated L3-22. It was 600 recently. 20% deposit habitat. You can date it as on CC. It will be allowed. The deposit amount will take.
Okay, person to which trial court 50,000 personal bond to show rupees PCR SC. Yes.
Number 40, Rudrapa P.
Person to which trial court 50,000 personal bond to show rupees PCR SCR formatting.
Number 40, Rudrapa P.
ನೀವು ಮಾಡಿ ಫೈಲ್ ಇಸ್ಕೊಂಬರ್ಬೇಕು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಇದೆ ಖಾಲಿ ಬಂದು ಟೈಮ್ ಪಾಸ್ ಮಾಡಿ ಅನ್ಲಿಕ್ಕೆ ಪಂಚಾಯಿತಿ ಅಲ್ಲ. ವಕೀಲರಾಗಿ ನೀವು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ನಿಲ್ತೀರಿ ಅಂದ್ರೆ ಕೈಯಲ್ಲಿ ಫೈಲ್ ಇರ್ಬೇಕು. ಚೀಲಿಯರ್ ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರು ಫೈಲ್ ನಿಮಗೆ ಕೊಡ್ಬೋದಲ್ವೇ? ರೀ ಅವ್ರು ಚಂದ್ರಲೋಕಕ್ಕೆ ಹೋಗ್ಲಿರಿ, ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಮನ್ನ ಕಳಿಸ್ತಾರೆ ಅಂದ್ರೆ ಫೈಲ್ ಕೊಟ್ಟು ಕಳಿಸ್ಬೇಕಲ್ವೇ? The proxy counsel for the petitioner is present. List the matter in the week after next. Any earlier listing would be only after bringing the today's observation to the notice of the court. Yeah.
Further arguments.
230 bit ಉಳಿದಿದ್ದು ಯಾವುದು?
Pass over matter. Serial number 2, Hegde Ramakrishna X.
Called again, none appear passed over. Dismissal. Called again, none appear passed over again.
Other hearing matters. Number 41. Political party correspondent.
The other side wanted argument. In the same case, right? More than one general power of attorney. What to do now? Neither the learned counsel for the petitioner on record nor the learned senior counsel who has partly argued this matter are present. The learned counsel for the respondent along with the learned senior counsel alone are physically present. That is possible.
Sir number 42, Ravindra B. Deshpande.
Or law point ಮೇಲೆ you have to highlight, say, are there any list?
4 point.
Yes. Next.
2 ಪವರ್ ಆಫ್ ಅಲ್ಲಿ ಬಾರ್ಡರ್ ಲಿಮಿಟೇಷನ್ ಕ್ಲೋಸರ್ ಆಫ್ ಅಕೌಂಟ್ ಆಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ಲಿಮಿಟೇಷನ್ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಕ್ಕೆ ಅಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂತ
Number 42, Ravindra B. Deshpande, SCGP for respondent.
Personation.
SSLC exam.
Science paper. That the documents seized have not been sent for forensic to establish that.
It was for your argument only now. Yes. Proceed, we will hear.
Yes. One submission to this honorable court. Imprecise. Learned trial judge in CC number.
The learned counsel for the petitioner has drawn attention of this court towards some portions of the evidence of PW1.
Yes.
And submitted that there are major contradictions in her evidence. So who impersonated whom is not clear in her evidence. She is the only material witness.
Yes.
So when the material witness herself is not clear and there is contradiction in her evidence,
Yes.
how to conclude that there was any impersonation? That was one of the primary point raised by the adversary.
Yes. Lordship.
ನಿಮ್ಮ ಕಲೀಗ್ ಇದ್ದಾರಾ ಇದರಲ್ಲಿ ನೀವಿದ್ದೀರಿ, ನೀವೇ ಇದ್ದೀರಿ.
Incident took place in the year 2000. Lordship, duly appreciate this fact. The evidence was recorded in the year 2006. After lapse of 6 years.
Loss of memory question ಬರಲ್ಲ ಅದರಲ್ಲಿ.
Yes.
ಫ್ಯಾಕ್ಟ್ ನಲ್ಲಿ
Yes.
ಇಂಪರ್ಸನೇಷನ್ ಅನ್ನೋದು ಇನ್ಸಿಡೆಂಟ್ ಬಗ್ಗೆ ಏನು ಕನ್ಫ್ಯೂಷನ್ ಇಲ್ಲ.
Yes.
Who impersonated whom? That was the criteria. ಅದರಲ್ಲಿ ಮೆಮೊರಿಯ ಕ್ವಶನ್ ಬರಲ್ಲ ಅದರಲ್ಲಿ.
Yes. Yes.
ಸೊ ನಿಮ್ಮ ಬದಲಿಗೆ ಒಂದು ಅಸ್ತ್ರ ಹೋಯ್ತು.
My reply is, I can't overcome the evidence recorded or the facts elicited in the course of process.
No, it is not overcoming, but you have every opportunity to convince the court
Yes.
that what is the significance of the alleged contradiction.
Yes.
That is argument.
Yes. I have a submission to this honorable court. So, on the date of incident, PW1 was physically present. She was come across with the difference in the signature on the hall ticket and that of the answer paper under exhibit P123. Now, for the brevity of the court, kindly that hall ticket, answer paper, and supervisor statements have been marked through this witness. Now, as far as the cross-examination is concerned, immediately after she came to know about the incident. She has taken the papers and the hall ticket, and she has yesterday
This matter yesterday, detailed evidence was also looked into in a nutshell, my lord. If by perusing the complaint, my lord, it is very-
What is the designation in the examination process of PW1? Was she a supervisor or superintendent or chief superintendent?
My lord, PW1 was headmistress, my lord.
No,
We have open-
she was headmistress, but not in the examination center. So far as the incident is concerned,
Please, my
she
lord.
can't be headmistress.
Please, my lord. That is during the.
What was she then? ಆಕೆ ಹೇಳಿದ್ದಾರೆ ವೆರಿ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. ನಾನು ಅದನ್ನು ತಮ್ಮ ಇಂಗ್ಲಿಷ್ ಭಾಷಾಂತರದಲ್ಲಿ ಕೇಳ್ತಿದ್ದೇನೆ ಅಷ್ಟೇ. ಮುಖ್ಯ ಅಧೀಕ್ಷಕಿಯಾಗಿ ಅಂತ ಹೇಳಿಲ್ವೇ ಆಕೆ?
ಹಿರಿಯ ಉಪನ್ಯಾಸಕರು ಜಿಲ್ಲಾ ಶಿಕ್ಷಣ ಮತ್ತು ತರಬೇತಿ ಸಂಸ್ಥೆ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ರಾಜರಾಜೇಶ್ವರಿ ನಗರ. On the date of deposing as PW1, she was
Deposing ಅಲ್ರಿ ವಕೀಲ್ರಿ. In the incident,
my lord, on the date
when she says that there was copying, there was impersonation of one person with another. Prashant Kumar impersonated another person, Chandrasekharaya,
please, my lord.
and wrote the examination. What was she? What made her to be present there?
Supervisor, my lord, on the date of the examination.
Was she supervisor or was she superintendent? ಇದೆಲ್ಲ ಬೇಸಿಕ್ ಥಿಂಗ್ಸ್ ಸರ್ಕಾರಿ ಪಕ್ಕಾ ಫಸ್ಟ್ ನೋಡ್ಕೊಳ್ಬೇಕು. ಸೂಪರ್ವೈಸರ್ ಜವಾಬ್ದಾರಿ ಬೇರೆ ಇರ್ತದೆ, ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಜವಾಬ್ದಾರಿ ಬೇರೆ ಇರ್ತದೆ.
ಪರೀಕ್ಷಾ ಮುಖ್ಯ ಅಧೀಕ್ಷಕರಾಗಿ
ನಾನು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಕೇಳ್ತಿದ್ದೇನೆ, ಅದನ್ನ ನಾನು ಓದಿದ್ದೇನೆ, ಅದನ್ನೇ ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇರೋದು ನಾನು. ನೀವು ಏನಂತ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ? Whether you have proceeded further treating her as a supervisor of the center or the examination hall or as a superintendent of the examination center. Superintendent of the examination center.
examination.
Yes, proceed.
Because based on the complaint letter addressed by the PW3, my lord, she proceeded to file this complaint for the investigation of this.
Yes, please.
Letter addressed by the PW3 is at exhibit P6, my lord.
ಕೊಡ್ಬೇಕು. PW6. PW1 exhibit.
PC.
Exhibit P3 remove the complaint. Yes.
But in this, she states that read, DBP ಚಾಲಕರ ಪ್ರೌಢಶಾಲೆ ಸೋನ್ಸೊಳ್ಳಿ ದಿನಾಂಕ 13/7/2000 ಮಧ್ಯಾಹ್ನ ವಿಜ್ಞಾನ 2ನೇ ಪೇಪರ್ ಕೊಠಡಿ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಕೊಠಡಿ ಮೇಲ್ವಿಚಾರಕ್ಕಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಆ ಸಮಯದಲ್ಲಿ ಪರೀಕ್ಷೆ ಪ್ರಾರಂಭದ ಅರ್ಥದಲ್ಲಿ ಟಿ ಚಂದ್ರಶೇಖರ್ ರಿಜಿಸ್ಟರ್ ನಂಬರ್ 12 ಎಂಬ ವಿದ್ಯಾರ್ಥಿ ಬದಲಾಗಿ ಪ್ರಕಾಶ್
ಅನುಮಾನ ಬಂದ ತಕ್ಷಣ ನಾನು ಇದನ್ನ ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. So this letter was forwarded to the PW1. In PW1 she clearly states ನಾವು ವಿಚಾರಣೆ ಮಾಡಿದಾಗ ಅವನ ಹೆಸರು ಪ್ರಕಾಶ್ ಎಂದು ಹೇಳುತ್ತಾನೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಬಂದಿದೆ. PW1 ನಲ್ಲಿ read exhibit P1 the relevant portion.
Exhibit
P1
Exhibit P1 is admission ticket, right?
Sorry, P3 is the complaint. Sorry, sir. Exhibit P3 is the complaint. From the relevant.
Yes, relevant portion.
From the fifth line, ದಿನಾಂಕ 13/7/2022 ಮಧ್ಯಾಹ್ನ ಜಿ ಚಂದ್ರಶೇಖರ್ ಎಂಬ ವಿದ್ಯಾರ್ಥಿ ಬದಲಾಗಿ ಪ್ರಕಾಶ್ ಎಂಬ ವಿದ್ಯಾರ್ಥಿ ಉತ್ತರ ಬರೆಯುತ್ತಿದ್ದ. ಪ್ರಕಾಶ್ ತನ್ನ ಫೋಟೋ ಅಂಟಿಸಿಕೊಂಡು ನಕಲಿ ಸಹಿ ಮತ್ತು ಸೀಲನ್ನು ಹಾಕಿಕೊಂಡು ಬಂದಿದ್ದನು. ಆದರೆ ಪ್ರವೇಶ ಪತ್ರದ ಮೇಲಿರುವ ಚಂದ್ರಶೇಖರ್ ಸಹಿ ಮತ್ತು ನಕಲಿ ವಿದ್ಯಾರ್ಥಿ ಮಾಡುವ ಸಹಿ ವ್ಯತ್ಯಾಸ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಇದನ್ನು ಪ್ರಕಾಶನನ್ನು ನಕಲಿ ವಿದ್ಯಾರ್ಥಿ ಪತ್ತೆಯಾಗಿರುತ್ತದೆ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ ಅವರು.
ವಿಚಾರಿಸಲಾಗಿ ಆತನು ತನ್ನನ್ನು ಪ್ರಕಾಶ ಎಂದು ಹೇಳಿದನು ಅಂತ ಎಲ್ಲಿ ಬಂದಿದೆ? ನೀವೀಗ ಹೇಳಿದ್ರಿ ವಿಚಾರಿಸಲಾಗಿ ಪ್ರಕಾಶ ಅಂತ ಹೇಳಿದ ಅಂತ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರಿ, ಅದನ್ನ ತೋರಿಸಿ.
ಕಂಡು ವಿಚಾರಿಸಲಾಗಿ ಪ್ರಕಾಶನು ನಕಲಿ ವಿದ್ಯಾರ್ಥಿಯಂತೆ ಪತ್ತೆಯಾಯಿತು. ವಿಚಾರಿಸಲಾಗಿ ಪ್ರಕಾಶ್ ನಕಲಿ ವಿದ್ಯಾರ್ಥಿ ಪತ್ತೆಯಾಯಿತು ಅಂತ ಹೇಳ್ತಾರೆ ಕಂಪ್ಲೇಂಟ್. ಅವರು ಇನಿಷಿಯಲಿ ಎನ್ಕ್ವೈರಿ
ಕೋರ್ಟ್ ನಲ್ಲಿ ಆಗೋದು ಸರ್ಕಾರಿ ವಕೀಲರು ಕನ್ನಡವನ್ನು ಯದ್ವಾ ತದ್ವಾ ಕೊಲ್ತಾರೆ. ಮುಂಚಿನಿಂದಲೂ ಗಮನಿಸ್ತಿದ್ದೇನೆ. ಲಾಸ್ಟ್ ಟೈಮೇ ಹೇಳಿದ್ದು, ಒಂದ್ಸರ್ತಿ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿಗೆ ಹೋಗಿ ಅಲ್ಲೇನಾದ್ರು ಕನ್ನಡ ಹೇಳಿಕೊಡೋರಿದ್ರು ಕೇಳ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ. ಪ್ರಕಾಶನು ನಕಲಿ ವಿದ್ಯಾರ್ಥಿಯಾಗಿ ಪರೀಕ್ಷೆ ಬರೆಯುತ್ತಿದ್ದುದು ಪತ್ತೆ ಆಯಿತು ಅನ್ನಲಿಕ್ಕೂ ಆ ವ್ಯಕ್ತಿಯನ್ನು ವಿಚಾರಿಸಲಾಗಿ ಆತನು ತನ್ನನ್ನು ತಾನು ಪ್ರಕಾಶ ಎಂದು ಗುರುತಿಸಿಕೊಂಡನು ಅನ್ಲಿಕ್ಕೂ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ ಅಲ್ವೇ? ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ ಅಲ್ವೇ? ನೀವು ಹೇಳಿದ್ದು, ನೀವು ಮಾಡಿದ ಸಬ್ಮಿಷನ್ ಆತನ ವಿಚಾರಿಸಲಾಗಿ ಆತ ತನ್ನನ್ನು ಪ್ರಕಾಶ ಅಂತ ಹೇಳಿದ ಅನ್ನೋದು ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲೇ ಬಂದಿದೆ ಸ್ವಾಮಿ ಅಂದ್ರಿ. ಆ ವಾಕ್ಯ ತೋರಿಸ್ರಿ ಅಂತ ಹೇಳ್ತಿದ್ದೇನೆ. ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿನ್ನೆ ಇದ್ದಿದ್ದು ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ. ಅವ್ರ ಪ್ರಕಾರ ಪ್ರಕಾಶ ಬಂದು ಬರಿತಾ ಇದ್ದ, ಆದ್ರೆ ನಾನು ಪ್ರಕಾಶ ಅಲ್ಲ ಪ್ರಶಾಂತ್ ಕುಮಾರ, ಅದು ಅವ್ರ ಪಾಯಿಂಟ್. ಹೌ ಡು ಯು ಓವರ್ಕಮ್ ದಟ್ ಅನ್ಲಿಕ್ಕೆ ಈ ಪ್ರಶ್ನೆ ಬರ್ತದೆ.
ಪತ್ತೆ ಆಯಿತು ಅಂತ ಅವರು ಹೇಳ್ತಾರೆ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕೂಡ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ.
ಹಾಗಾದ್ರೆ ನೀವು ಪ್ರಕಾಶ ಬರೀತಿದ್ದ ಅಂದ್ರೆ ಪ್ರಶಾಂತ್ ಕುಮಾರ್ನ ಯಾಕೆ ಹಿಡ್ಕೊಂಡ್ರಿ?
ಅಲ್ಲ ಅಲ್ಲಿ FIR ಕೂಡ ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್ ಆಗಿದ್ದು ಪ್ರಕಾಶ್ ಅಂತಾನೆ ಆಗಿದೆ. ಪ್ರಕಾಶ್
ಹೌದ್ರಿ, ಅದನ್ನ ಅವರೇ ಹೇಳಿದಾರ್ರಿ, ನೀವ್ ಹೇಳೋದಲ್ಲ. ಅವರ ಫೇವರಿಗೆ ಇದೆ ಅದು ಅಂತ ಅಕ್ಯೂಸ್ಡ್ ಹೇಳಿದ್ದಾರೆ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಪ್ರಕಾಶ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, FIR ಅಲ್ಲೂ ಪ್ರಕಾಶ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Admittedly, I am not Prakasha, I am Prashant Kumara. Therefore, at the foundation level itself, their case goes that if at all anybody else has written the examination in the place of Chandrasekhara, that was one Shri Prakash, but not me, Prashant Kumar. That is their argument. How do you overcome that? ಈಗ ಬರ್ತದ I cannot improve any further case. What is there in the material ಅಂತ? ಅವೆಲ್ಲ ಅಸ್ತ್ರಗಳು ಬತ್ತಳಿಕೆಯಲ್ಲಿ ಇರ್ಲಿಕ್ಕೆ ಯೋಗ್ಯವಲ್ಲ. ಅದು ತೆಗಿಬೇಕು. ಹೇಳಿ.
to look into the court records.
ಕೊಡಿ ಅವ್ರು ಏನ್ ಕೇಳ್ತಾರೆ. You have any information whether the other accused paid the fine or whether he has preferred any revision?
After the pay the fine and please
Must be.
A2.
Passport serial number 2.
Matter serial number 2.
Why don't I impose cost? ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ರಿಪೀಟೆಡ್ಲಿ ನೀವು ಅದನ್ನ ಮಾಡ್ತೀರಿ, ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ. ಫಸ್ಟ್ ಒಮ್ಮೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಆಮೇಲೆ ನಾನು ಕೇಳಿದ್ರ ಮೇಲೆ ಡಾಕೆಟ್ ಇಂದ ಒಂದು ಮೆಮೊ ತೆಗಿತೀರಿ. ಅದನ್ನೇ ನಾನು ಪ್ರಾಮಾಣಿಕತೆಯ ಕೊರತೆ ಎನ್ನೋದು. ಕೋರ್ಟ್ನ ಟೆಸ್ಟ್ ಮಾಡೋದು ಇಲ್ಲ, ಬಹಳ ಕ್ಲಿಯರ್ ಇದೆ ಕೋರ್ಟಿನ ವ್ಯೂ ಅಂತ ಹೇಳಿದಾಗ ಆಮೇಲೆ ತೆಗೆಯೋದು ಮೆಮೊ, ಲಿಬರ್ಟಿ ಟು ವಿಡ್ರಾ ಅಂತ. That is not healthy practice. That is not healthy practice.
I have not that intention.
ಮತ್ತೆ ಅದನ್ನ ಒಳಗಡೆನೂ ಇಟ್ಕೊಂಡು ಮೇಂಟೈನಬಿಲಿಟಿ ಬಗ್ಗೆ ಯಾಕೆ ಹೇಳಲಿಕ್ಕೆ ಹೋದ್ರಿ? Knowing fully well that it is not revision petition that lies, but you have got the remedy before the same court, not under revision petition, not under revision. You are pretty aware of that. Simple one sentence. I may be permitted to withdraw that with liberty to file a proper petition ಅಂದ್ರೆ ಮುಗಿದು ಹೋಗಿ ಬಿಡ್ತಿತ್ತು ಕತೆ. ಆ ಮೆಮೊ ರೆಡಿ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದೀರಿ, ಆದ್ರೂ ಅದನ್ನ ಕೊಡ್ಲಿಕ್ಕೆ ತಯಾರಿಲ್ಲ, ಬೇರೆದೇ ಹೇಳೋದು. ನೀವು ಕೋರ್ಟ್ ಒಬ್ಬನ ನೀವು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಥವಾ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡಿದ್ರೆ ಹಿಂದೆ ಕೂತರು 35 ಜನ ನಿಮ್ಮನ್ನು ಅಬ್ಸರ್ವ್ ಮಾಡ್ತಾರೆ.
I beg your pardon for the wasting of
Please. Called again in the third round. Lawyer counsel for the petitioner files a memo seeking withdrawal of this petition with the liberty to file an appropriate petition. If you are seeking
conversion,
like withdraw ಬರಲ್ಲ, ಕನ್ವರ್ಷನ್ ಎರಡೂ ಆಪರ್ಚುನಿಟಿ ನಿಮಗೆ ಇದೆ. Whichever you feel better ಮಾಡಬಹುದು.
I seek for conversion.
Conversion. ಪಕ್ಕ. ಆಮೇಲೆ I shouldn't have ಅಂತ ಅನ್ಕೊಳ್ಬಾರ್ದು ನೀವು.
I may permit it to
lock AHI.
Save the time of
ಟೈಮ್ ಏನ್ ಸೇವ್ ಆಗೋದಲ್ಲ. ನೀವು ಮಾಡೋದನ್ನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬೇಗ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದನ್ನ ಬೇಗ ತಗೊಂಡ್ಬಿಟ್ರೆ ಅದಕ್ಕಿಂತ ದೊಡ್ಡ ವರದಾನ ನ್ಯಾಯಾಧೀಶರಿಗೆ ಬೇರೆ ಇಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾದ್ರೆ 2 ದಿವಸ ತಗೊಳ್ಳಿ, ಖುಷಿಯಿಂದ ಕೇಳುವ. 25 ರೂಪಾಯಿ ಪ್ರೋಸೆಸ್ ಕಟ್ಟೋದು, ಒಂದು ಪೇಜಿನೇಷನ್ ಮಾಡೋದು, ಅದ್ರಲ್ಲಿ 3 ವರ್ಷ ಎಳ್ಕೊಂಡು ಹೋಗೋದು. ಮೇಂಟೈನಬಿಲಿಟಿ ಅಲ್ಲದೆ ಇರ್ಬೇಕಾದ್ರೆ ಮೇಂಟೈನಬಲ್ ಅಂತ ಹೇಳಿ 4 ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡು ಮತ್ತು ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳೋದು, ಅವುಗಳನ್ನ ನಿಲ್ಸಿ ಬಿಟ್ರೆ ಅದಕ್ಕಿಂತ ದೊಡ್ಡ ವರದಾನ ಬೇರೆ ಬೇಡ. ಎಕ್ಸ್ಟ್ರಾ ಜಡ್ಜು ಬೇಡ, ಎಕ್ಸ್ಟ್ರಾ ಕೋರ್ಟು ಬೇಡ. ಇರಾ ಜಡ್ಜ್ಗಳು, ಇರಾ ಕೋರ್ಟ್ಗಳು ಎಕ್ಸಲೆಂಟ್ ಡಿಸ್ಪೋಸಲ್ ಕೊಡ್ತೇವೆ. ಏನ್ ತಗೊಂಡು ಕನ್ವರ್ಟ್ ಅಲ್ಲಿ ವಿಡ್ರಾ ಕನ್ವರ್ಟ್ ಎದುರು ಬರ್ದಿದ್ದೀರಿ, ವಿಡ್ರಾ ಹೊಡೆದಾಕಿ ಕನ್ವರ್ಟ್ ಎಲ್ಲ ರಿಟೈನ್ ಮಾಡಿ ಒಂದು ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ಇಂಥವ್ರು. ಸೀಕಿಂಗ್ ಕನ್ವರ್ಷನ್ ಆಫ್ ದಿಸ್ criminal revision petition into a writ petition. Third is submission. Who makes a submission? Third is submission of learned counsel which is on the line of his memo. The registry also has raised an objection regarding maintainability of this revision petition. In view of the above, the conversion of sought for is granted. The registry is directed to permit a conversion of this criminal revision petition into a writ petition filed under section 226 or 227 article.
ನಾನು 482 ಅಂತ ಹಾಕಿದ್ದೀನಿ. ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅಂಡರ್ 482.
482 ನಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಬರುತ್ತಾ ವಕೀಲರೇ?
226
ನೋಡಿ, ನೀವು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೀರಿ. ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಕೆಸರಿನ ಹೊಂಡದಲ್ಲಿ ಆಳಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದೀರಿ. ಬಹಳ ಸಿಂಪಲ್, ಬಹಳ ಸರಳವಾಗಿದ್ದನ್ನ ನೀವಾಗಿ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಿದ್ದೀರಿ. 482 ಸೆಕ್ಷನ್ 482 CRPC ರಿಟ್ ಪಿಟಿಷನ್ ಬರಲ್ಲ ಅಲ್ವೇ? ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಇದ್ದೀರಿ ವಕೀಲರೇ ತಾವು. ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ, ನೋಡಿ ಸರಿಯಾದ ಪ್ರಾವಿಷನ್ ಹಾಕಿ, ಅವಾಗ ಗ್ರೌಂಡ್ಸ್ ಗಳನ್ನು ನೀವೇನಾದ್ರು ಇಂಪ್ರೂವ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಒಂದು ಅವಕಾಶ ಇರ್ತದೆ ಅಲ್ವೇ? ಇನ್ನೊಮ್ಮೆ ಗ್ರೀನ್ ರೂಮ್ ಕರ್ಕೊಂಡು ಹೋಗಿ ಚಂದ ಮೇಕಪ್ ಮಾಡಿ ಮತ್ತೆ ಕರ್ಕೊಂಡ್ ಬರ್ಬೋದು.
I will be permitted to withdraw the certificate copy of the order.
ವಿಡ್ರಾ ದಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಬರಲ್ಲ.
Return.
ಹಾ, ಕನ್ನೋಟ ತೆಗಿಸ್ಲಿ, ವಿಡ್ರಾ ಇಟ್ರು. ನೋಡಿ ನಿಮ್ ಕೆಲಸ ನಾವು ಮಾಡ್ಬೇಕಿಲ್ಲಿ. ಏನ್ ತಗೊಂಡ್ರಿ? Adali, Laret called again the third round. Laret counsel for the petitioner has filed a memo seeking withdrawal of this revision petition, however, with the liberty to file a fresh petition in accordance with law. The registry also has raised an objection regarding the maintainability of these revision petitions. In view of the above, this revision petition stands disposed of as withdrawn, however, reserving liberty to the petitioner to file appropriate petition in accordance with law. The second copy of the impugned order be returned to the petitioner upon his request, however, after retaining an authenticated copy of the same for the records. Yes. ಇನ್ನೊಬ್ರು ವಕೀಲರು ಯಾರಿಗೆ ಕಾಯ್ತಾ ಇದ್ದೀರಿ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ? ಈಗ ಅಲ್ಲೊಬ್ರು ಕೂತಿದ್ರಲ್ಲ, ಎದ್ದು ಹೋದ್ರ? ತಮ್ಮದಲ್ಲ, ತಾವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್, ಇನ್ನೊಬ್ರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಕಾಯ್ತಿದ್ದೀರಿ. ನೀವು ಫೋನ್ ಮಾಡಿ ಅವರಿಗೆ ಬಿಲ್ ಕಳಿಸಬಹುದು. ಅಥವಾ ಅವ್ರು ಬಂದಾಗ ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್, ಮೈ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಈಸ್ ಆನ್ ಇಸ್ ಲೆಗ್ಸ್ ಇನ್ ಅನದರ್ ಕೋರ್ಟ್ ಅನ್ಬಹುದು. ಯಾವ್ದಾದ್ರು ನಿಮ್ಗೆ ಬಿಟ್ಟು ನಿಮ್ಮದು ಪಾಸ್ ಓವರ್ ಅಲ್ವೇನ್ರಿ? ಅಲ್ಲ. ಕಾಲ್ಡ್ ಅಗೇನ್ ದಿ ಥರ್ಡ್ ರೌಂಡ್. ಬಾಲರಾಜ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? Not percent. Pass over again. Yes. So continue ಮಾಡ್ರಿ, ನಿಮ್ದು ನೋಡಿದ್ರೇನ್ರಿ ಫೈಲು?
Voluntary statement of accused ಅಲ್ಲಿ
ಅದು ಹೇಗೆ ಬರ್ತದೆ?
He admits that he is Prashant, not Prakash ಅಂತ voluntary statement. It's part of charge sheet. The exhibit P10 P11.
ಐಒ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಬಂದಿದೆ ಆ ಕುರಿತಂತೆ? Whether the investigating officer has stated that though FIR was registered in the name of Prakash showing him as an accused, however, during the investigation, it was revealed that he was not Prakash, but he was Prashant Kumar. In that regard, the accused himself has given a voluntary statement, which I now see and mark it as exhibit so and so. ಹೇಳಿಸಿದ್ದೀರಾ?
ಮಾರ್ಕ್ ಆಗಿಲ್ಲ, ಅದು exhibit P10 ಅಂತ ಮಾರ್ಕ್ ಆಗಿದೆ. ಅನ್ನಪೂರ್ಣ ಅವರ statement PW3 statement has been marked.
She has disowned everything. She has turned hostile, right?
Not partially, she turned hostile. She does not identify the accused. And she was considered a hostile. But her statement was marked as at exhibit P10. In her statement, she states ವಿಚಾರಣೆ ಮಾಡಿದಾಗ ಅವನು ಒಪ್ಕೊಂಡಿದ್ದಾನೆ.
Has she admitted that she has given her statement as per exhibit P10 to the investigating officer?
Please.
PWP. ಪೂರ್ತಿ ಓದ್ಬೇಡ್ರಿ. P10 ಎಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿಸಿದ್ದೀರಿ? ಹಾಸ್ಟೆಲ್ ಅದ್ರ ಮೇಲೆ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಓದಿ ಮಾರ್ಕ್ ಮಾಡಿಸಿರ್ತೀರಿ ನೀವು. ಅದಕ್ಕೆ ಬಿಗಿನಿಂಗ್ ಇಂದ ಯಾಕೆ ಓದ್ತೀರಿ? ನೀವು P10 ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. P10 ಯಾಕೆ ಡಿಸೋನ್ ಮಾಡಿದಾಳೆ? ಹೌ ಕ್ಯಾನ್ ರಿಲೇ ಅಪಾನ್ P10 ನಾವು? ಅಲ್ವೇ? ಕಂಟಿನ್ಯೂಸ್ ಬನ್ನಿ, ಒಂದ್ ತಿಂಗಳು ನಿಮ್ಮನ್ನು ಪರ್ಫೆಕ್ಟ್ ಮಾಡುವ. ಮತ್ತೆ ಹೇಗೆ ಹೇಳ್ತೀರಿ ನೀವು ಪ್ರಶಾಂತ್ ಕುಮಾರ್ ಒಬ್ಬನೇ ಅಂತ? 50 ಹೇಳ್ತಿದ್ದೀರಾ? ಹೇಳ್ಸಿಲ್ಲ, ಬಂದಿಲ್ಲ. ಸೊ ಹಾಗಾದ್ರೆ ನೀವು ಯು ಕನ್ಸೀಡ್ ದಟ್ ದೇ ಆರ್ 2 different persons ಅಂತ ಬರ್ಕೊಳ್ಬಹುದಾ ನಾನು? Learned HCGP concedes that alleged Prakash and present petitioner Prashant Kumar are 2 different persons.
Since the SCGP himself consistently said fact, the very charge sheet filed against a wrong person stands vitiated.
Submission is one person.
ಅದನ್ನೇ ನೀವು ಹೇಗೆ ಮಾಡ್ತೀರಿ? You have to substantiate your statement. Substantiate that because they have raised that doubt.
I understand what the question is. Completely.
Yes.
Entire crux of the matter is
Revolves around that. ಜಾಸ್ತಿ ಸಮಯ ತಗೊಳ್ತಾ ಇದ್ದೀರಿ. What are your points of arguments?
I've been stuck down, my lord, only with respect to the question which has been posted by my lordship. PW1, my lord, Shailaja Kumari, who was the witness, my lord, at the point of time, she is an eyewitness, my lord. She identifies the accused. And PW2, my lord, Tanna, who is also a school teacher, my lord, he also identifies the accused in the court. And that has come in the chief examination. He further states that at the time of incident, I went to the spot and I saw the incident that number 1 was writing the exam in the place of accused. And PW3 Annapurnama, she turns hostile. PW4, 5, 6, they turned hostile.
PW1, PW2 ಎಲ್ಲಿ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ ಅಕ್ಯೂಸ್ ನ ಕೋರ್ಟಿನಲ್ಲಿ?
Page number 3, madam. One cross examination. Seventh line.
Yes.
ಆಗ ಎರಡನೇ ಆರೋಪಿ ನಕಲಿ ವಿದ್ಯಾರ್ಥಿ ಅಂತ ಗೊತ್ತಾಗಿ ಕೂಡಲೇ ಪೊಲೀಸರಿಗೆ ಫೋನ್ ಮಾಡಿ ವಿಷಯ ತಿಳಿಸಿದೆ. ಎರಡನೇ ಆರೋಪಿಯನ್ನು ನಾನು ವಿಚಾರಿಸಿದೆ. ಆಗ ಆತ ನಾನು ಚಂದ್ರಶೇಖರ್ ಅಂತ ಹೇಳಿ ಅದು 1ನೇ ಆರೋಪಿ.
ಸೆಂಟೆನ್ಸ್ ಓದಿ ಗಡಿಬಿಡಿ ಮಾಡ್ಕೊಳ್ಬೇಡಿ.
ಆಗ ಚಂದ್ರಶೇಖರ್ ಅಂತ ಹೇಳಿದ. 2ನೇ ಆರೋಪಿ ಚಂದ್ರಶೇಖರ್ ಅನ್ನು ಗುರುತಿಸುತ್ತೇನೆ. ಈಗ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ನಿಂತಿರುವ 2ನೇ ಆರೋಪಿ ಸದರಿ ಚಂದ್ರಶೇಖರ್ ಆಗಿರುತ್ತಾನೆ.
ಚಂದ್ರಶೇಖರ್ ಒಬ್ಬ ಆರೋಪಿ ಆಗಿದ್ದ ಅಲ್ವೇ? ಅವನು 2ನೇ ಆರೋಪಿನೇ ಆಗಿದ್ದ ಅಲ್ವೇ? ಮತ್ ಈಗ ಗುರುತಿಸಿರೋದು 2ನೇ ಆರೋಪಿ ಚಂದ್ರಶೇಖರ್ನನ್ನ ತಾನೆ. ಮತ್ತ ಅದು ತಪ್ಪೆಲ್ಲಿ ಆಗ್ತದೆ? 2ನೇ ಆರೋಪಿ ಚಂದ್ರಶೇಖರ್. ನಮ್ಮ ಮುಂದೆ ಈ ಕೇಸಿನಲ್ಲಿ ಈಗ ಇರೋದು 2ನೇ ಆರೋಪಿ ಅಲ್ಲ, 1ನೇ ಆರೋಪಿ. ಆ 1ನೇ ಆರೋಪಿನ ಗುರುತಿಸಿದಾರ ಹೇಳಿ. ಕೂತ್ಕೊಳ್ಳಿ. Action of conviction, IPC offense. All other matters at 2:30 p.m. The summary of the case of the prosecution, the trial court was that on the date 13/7/2000 between 2 p.m. to 3 p.m. at DVP High School, at room number 2 in DVP High School, CN Halli town, within the limits of respondent police station. The present revision petitioner was writing Science Part 2 SSLC examination paper impersonating the true candidate by name GT Chandrasekhara, son of GC Gopaya, bracket accused number 2 in the trial court, and was caught red-handed, and thus has committed The offense punishable under section 417, 419, 420, and 109 of Indian Penal Code. Really examined so and so PW exhibits so the after hearing both sides, the trial court by its impugned judgment dated 22/5/2012. Convicted both the accused number 1 and 2 for the offense punishable under section 417, 419, 420, and 109 of Indian Penal Code and sentenced them accordingly. Agreed by the same, both the accused prefer an appeal under section 374(3) of CRPC in criminal appeal number 81 of the 2012 in the court of so and so, Brevity Session Judges Court, which after hearing both sides by its impugned judgment dated 29/5/2013, partly allowed the appeal, modifying the judgment and order on sentence passed by the trial court in CC number 266 of 2001, dated 22/5/2012, and acquitted both the accused for the offences punishable under sections 417, 420, and 120B of Indian Penal Code. However, the conviction of both the accused and order on sentence for the offence punishable under section 419 of IPC was retained unaltered. Agreed by the same, the accused number 1 in the trial court has preferred this criminal revision petition. Notice records the argument single point argument warrants and interference. Learned counsel for the petitioner in his argument submitted that there is contradiction in the evidence of PW1 with that of her complaint, who in her evidence has stated that PW1 came to know, who in her evidence has stated that she came to know that accused number 2 was the accused who was imitating the true candidate, whereas the true candidate was accused number 2 and the one who was personating him was accused number 1. Thus, there is a major contradiction between the complaint and the evidence of PW1. He further submitted, even in the evidence of PW, he further submitted that the same witness, that is PW1, has further stated that the police verified the spot where accused number 2 was sitting in the examination hall. Whereas the case of the prosecution is that it was accused number 1 who was sitting in the examination hall and was rating the examination, personating accused number 2. As such, they said contradiction is fatal to the case of prosecution. Current counsel that there is no variation in the signature of accused number 2 in exhibit P1A to that of exhibit P2A. However, both the courts have held that the signature varies. As such, there is impersonation of accused. As such, there is impersonation of accused number 2 by accused number 1. Current counsel further submitted that the complaint as well as the FIR shows the name of the accused who is alleged to have personated the alleged true student, that is accused number 2, as one Shri Prakash, whereas the charge sheet was filed against Prashant Kumar, who is the present revision petitioner. Therefore, in view of such an ambiguity in the identity of the accused, the prosecution case should have been dismissed and disbelieved by both the trial court as well as the session judges court. This is prayed to allow the revision petition. Per contra, learned CGP for the respondent in his single sentence argument submitted that since both the trial court as well as the session judges court have appreciated the evidence placed before them in the proper perspective, the impugned judgments does not warrant any interference at the hands of this court. That. Among the 5 witnesses examined by the prosecution, among the 8 witnesses examined by the prosecution on its behalf, admittedly, PW1, CW so-and-so, Shailaja Kumari was not only the headmistress of Government High School, Chikkanayakanahalli, where the accused number 2 was said to be studying in 10th standard, bracketnally, to appear for SSLC examination. But also she was Chief Superintendent of examination, SSLC examination, including the center at DVP High School, CN town, where the alleged incident is said to have taken place. Her evidence on these lines have not been denied or disputed from the accused in her cross-examination. Similarly, the evidence of PW2, CW4, T. Murthanna, the assistant teacher, Government High School, that at the time of alleged incident, on the date of alleged incident, he was working as assistant superintendent of examination in DVP High School at CN Halli. And also his further evidence that the accused number 2 was his student for 2 to 3 years has not been denied or disputed in his cross-examination. So furthermore, the evidence of PW3, CW2, Annapurnamma, that she too was working as a teacher in a school, and that for the SSLC examination, During the period of March 2000, she was appointed as a supervisor at Government High School, Chikkanaikanahalli. And that on the date of alleged incident, which was on 13/7/2000, she was working as a room supervisor for Science Paper 2 examination scheduled to be held, which was held between 2:30 to 3:30 p.m. Date Bantali and 13/7 has also not been disputed from the accused side. It is in the accused side. However, the present division petitioner, bracket accused number 1, has denied contention that he had personated accused number 2, Chandrasekhara, and was falsely writing Science Paper 2 SSLC examination paper. Science Paper 2 in SSLC examination at Government High School, DVP High School CN town. The examination ನಡೀತಿರೋ ಜಾಗ DVP. ಅದನ್ನ ಎಲ್ಲ ಕಡೆ ನೋಡಿ. In the light of the above undisputed facts, the evidence of prosecution witnesses are required to be analyzed. PW1, the chief superintendent of the examination center, has stated that on 13/7/2000 in the afternoon, when the examination for Science Paper 2 SSLC examination was going on, CW2 bracket PW3 was working as room supervisor. It came to the notice of room supervisor as well as to her notice that in the place of a student by name GT Chandrasekhara, another person is rating the examination. She said, examination. The witness stated that immediately she went to the room, and when he inquired that other person who was rating, pretending that he is GT Chandrasekhar, told his name as Prakasha. She ascertained that the said Prakasha was rating the answer paper on behalf of the actual student, Sri GT Chandrasekhara. She cross-checked the admission ticket shown by said Prakasha, where she noticed that the photograph of the student was substituted from that of GT Chandrasekhara to the personating candidate, the personating student who was rating the examination on behalf of said Chandrasekhara. Noticing that the said photograph was a substituted photograph which was lacking her signature, she collected the said admission ticket and collecting the answer sheet, pro forma given to the supervisor on the exam, pro forma given to the room supervisor. She informed the police over the phone immediately. Later, she lodged a complaint as per Exhibit P3 to the police, along with the documents including admission ticket, answer script, statement of personating student who identified himself as Prakash, statement of the room supervisor, and a question paper. The witness has identified the admission ticket at Exhibit P1 and stated that the photograph affixed to that was of the person who was rating the examination, and it was that photograph that was substituted instead of the actual photograph of Chandrasekhara, upon which she had put her signature. She also identified the signature of the actual candidate in the admission ticket with that of her signature and also her signature. At Exhibit P1A and P1B, she identified her signature in the admission ticket at Exhibit P1A, and the photograph of alleged personating student, that is accused number 1, bracket present petitioner, at Exhibit P1B. It has also identified got marked pro forma that have been given by her as chief superintendent to the room supervisor and issued by KSEE Board Bengaluru at Exhibit P2. The signature of accused number 2 therein at Exhibit P2A. She stated that there was, as noticed by her, there was variation in the signature between signature that was found in Exhibit P1 to that of Exhibit P2A. The witness has also identified, got marked as a complaint at Exhibit P3. Question paper at Exhibit P4. Question paper, the SSLC Science 2 paper. SSLC Science Paper 2 question paper as Exhibit P4. Answer sheet said to be have written by accused number 1 at Exhibit P5. P5 report said to have been given by PW3 to her at Exhibit P6. Statement said to have been given by accused number 1 before her at Exhibit P7. The witness further stated, Sapara, that when she produced all the above documents before the police, they drew a Caesar Panchanama, which Panchanama the witness has identified at Exhibit P8. She also stated that the police, after visiting the place of the offense, have drawn a Panchanama in her presence and also in the presence of CW4 bracket PW2 Murthanna and Narayana Swami, and has identified the said scene of offense Panchanama at Exhibit P9. This witness was subjected to a detailed cross-examination from the accused side, wherein she adhered to her original version On the other hand, she has given more information and details about the total number of students who were writing the examination and in the centers under her supervision. In the centers under her superintendence on that day. And also the procedure of conducting the examination. She has also given the details as to at what time the students would be allowed inside the examination center and up to what, at to what time and up to what time the students would be allowed to write. Write the examination and also the process of conducting the examination. She denied the suggestion that the signatures at Exhibit P1 and Exhibit P2A are uniform and that there are no variation. She denied a suggestion that the parents of the accused had the parents of accused number 2 once had been to her school when she had initiated action against accused number 2. As such, as a revenge, she has filed a false complaint against the accused. However, the witness has denied all those suggestions made to her. PW2, CW4, P. Murthanna. The assistant superintendent of examination on the date of the alleged incident has stated that while he was going on rounds in the examination center on 13/7/2000 in the afternoon between 2 to 3 p.m., he noticed that Srimati Annapurnamma, bracket CW2/PW3, the room supervisor, was inquiring accused number 1 and questioning him that he was personating the true candidate. He was not the true candidate of the student and that he was personating the true student. It is stated that later on, accused number 1 was taken to the chambers of the chief officer. The chief superintendent and Annapurnamma ascertained by making inquiry that accused number 1 was a fake student, candidate, and that he was writing the examination on behalf of accused number 2, Chandrasekhar. The witness stated that he has seen accused number 1 and accused number 2 to 3. And accused number 2 was his student for about 2 to 3 years. The witness has identified both the accused in the court, both the accused in the trial court. He further stated that the documents produced by the chief superintendent, bracket PW1, before the police were seized in his presence by drawing a Panchanama, which the witness has identified at Exhibit P8. The witness has also stated that a scene of offense Panchanama after Exhibit P9 was also drawn in his presence. The witness has identified the admission ticket at Exhibit P1 stating that he had seen the said admission ticket on the date of incident. Even this witness also was subjected to a detailed cross-examination wherein he adhered to his original version. PW3, CW2, Annapurnamma, though has stated that she was working as a room supervisor in the examination center for SSLC examination, on the date of incident, and that science paper 2 examination was going on the said day between 2:30 to 3:30 p.m. She stated that she is not aware as to what happened on the said day. Though she stated that the squad people had visited the said room where 28 students were writing their examination, she further stated that she is not aware as to what the squad noticed. She further stated that she was not aware as to what was noticed by the said squad. However, she stated that the squad people detected a case and stating that a boy who was writing the paper should not write that paper. Took back the answer script from him. However, she does not remember as to who that boy was. But the witness stated that she had obtained the signatures of students on the proforma at exhibit P2. She stated that she has not given any report to the chief superintendent of the examination center, and also has not given any statement before the police. So, since this witness was projected as a room supervisor of the examination hall, where accused was said to have tried where the accused were said to have committed the alleged offense, and that it was she who was said to have suspected the personation of accused number 2 by accused number 1, and given a statement to that effect before the investigating officer, the prosecution was permitted to treat this witness as hostile and to cross-examine her. However, prosecution, except suggesting to the witness that she had given her statement before the investigating officer as per exhibit P10, did not elicit any, did not put any question to the witness, neither put any question to the witness, nor elicited any further statements from her. PW4, CW5, Chand Pasha. PW5, CW6, K. Chandrasekhara. PW6, CW7, Chandrasekhara. ಚಂದ್ರಶೇಖರ ಒಬ್ಬ ಕೆ ಚಂದ್ರಶೇಖರ, ಇನ್ನೊಬ್ಬ ಚಂದ್ರಶೇಖರ, ಎರಡನೇ ಆರೋಪಿ ಚಂದ್ರಶೇಖರ. ಚಂದ್ರಶೇಖರಗಳಿದ್ದಾರೆ ಇವತ್ತು ದಿವಸ. ಚಂದ್ರಶೇಖರ, though were projected as co-students writing the very same examination, very same subject matter question paper, the very same subject matter examination in the very same room at the time of incident. However, all these three witnesses, except stating that they had attended the examination on the said day at the place of alleged offense, have expressed their ignorance about other details of the other details with respect to the alleged offences. They expressed their ignorance as to the occurrence of the alleged incident in the center. Even after treating them hostile, the prosecution could not be able to elicit any further details from them. Yeah. PW 7. CW 10. Habibullah. PW 8, CW 8. Rahmatullah Gauss, being the investigating officer, have given their evidence about the investigation activities conducted by them in the matter. Yeah. In the light of the above, as already observed, in the light of the above evidence of the prosecution witnesses, as already observed above, the undisputed fact remains that on 13/7/2000, science paper 2 of SSLC examination was held in several centers, including DVP High School at CN Halli Town, where PW1 was the chief superintendent, PW2 was assistant superintendent, and PW3 was the room supervisor. It's also not in dispute that accused number 2, GT Chandrasekhara, was issued with an admission ticket to write the said SSLC examination, including the science paper 2, which was held on 13/7/2000 between 2:30 p.m. to 3:30 p.m. in the very same DVP High School, CN Halli Center. And that PW3 was the room supervisor at that time. According to prosecution, where it was at the instance of PW3, PW1 went to the room where accused number 1 said to have been writing the answer paper showing himself as accused number 2, and caught hold of him red-handed and then lodged a complaint against him. However, PW3, this room supervisor, has not stated about she giving any such information to PW1 in that regard. Thus, in that regard. Therefore, the source of information about the alleged impersonation, which according to PW1 was given to her by PW3, was disowned by PW3. However, by that itself, it cannot be concluded that there was no such incident taken place in the said center, since PW2, who undisputedly was assistant superintendent of the center, has in his evidence clearly stated that while he was taking rounds at the time of the said examination, he noticed that PW3 bracket Annapurnamma was questioning a student and objecting that he was not a genuine candidate. The witness has also stated that he has seen the admission ticket in dispute on the very same day. There is further evidence that thereafter the matter was taken before PW1, the chief superintendent, and who held inquiry and proceeded further in the matter, would clearly go to establish that such an alleged incident of alleged personation of one student by another and writing science paper 2 answer paper in SSLC examination stands established. Fair. The learned counsel for the petitioner, though submits that he would not dispute the dispute the conduction of examination of Science 2 paper at DVP High School, CN Halli, on 13/7/2000. However, his contention is that at that time, accused number 1 was not in that room where impersonation is said to have taken place. As such, he had no role to play in the alleged offense of personation of accused number 2 by another person. It is in that regard, his first point of argument, his first contention was that in identification of the accused or narrating about the incident, there is contradiction in the evidence of PW1 between her complaint at Exhibit P3 and her evidence. In that regard, the learned counsel attempted to, learned counsel brought to the notice of the court that in the complaint, the complainant, bracket PW1, has stated that accused Chandrasekhara, accused Prakasha, had personated accused number 2 Chandrasekhara by showing himself as Chandrasekhara. Whereas in her evidence as PW1, she has stated that she came to know that accused number 2 was a deceptive student. Thus, the witness herself is not clear as to who was personating whom. And there is thus there is contradiction between her complaint and to that of her evidence in examination in chief. He also submitted that the very same witness has further stated the police visited the spot where the accused number 2 was sitting in the room and investigated. Thus, even according to the witness, the person who had written the examination was accused number 2, but not accused number 1. The said argument of learned counsel. A careful and detailed reading of the evidence of PW1 in its entirety and also her complaint at Exhibit P3 would go to show that throughout she has stated both in her complaint as well in her evidence as PW1 that the true student who was supposed to and expected to write Science 2 paper on the said day was one by name G.T. Chandrasekhara. Whereas she saw that other person who with his inquiry disclosed himself as Prakasha was writing the examination. However, while giving the evidence in the court, at some places she has referred to the accused with their serial number as accused number 1 and 2, and sometimes with their name. In the said process, she has committed some mistake in mixing up the accused's apostrophe S serial number with that of the name of the accused. By that itself, it cannot be called that it is a material contradiction. Furthermore, the alleged contradiction between her complaint and the alleged her deposition was not confronted to the witness in a manner known to law. Had such an alleged contradiction, alleged variation or discrepancy was brought to her notice, either she would have given clarification with the name or the correct accused number, or she would have given explanation as to what made her to say so. As such, without confronting the alleged variations or contradiction in the statement, merely by making a comparison between the complaint and her alleged complaint and her evidence in the examination chief, now it cannot be said that it is a contradiction. However, even assuming that the same would be a contradiction, still it is too minor to imbibe any doubt in the case of prosecution or demolish the case of prosecution, since, a reading of, as observed above, a reading of the evidence of PW1 in its entirety clearly go to show that the person who was rating the examination in the place of accused number 2, GT Chandrasekhara, was not the true GT Chandrasekhara, but it was somebody else. The sum and substance of the evidence of PW1 and the evidence of PW2 is that there was personation of genuine student Chandrasekhara by another person who, according to them, is accused number 1 herein. That is the present petition. Therefore, the argument of the learned counsel for the petitioner that there is a contradiction in the case of prosecution, making its case doubtful, is not acceptable. The second argument of learned counsel for the petitioner was that there is no much variation between the signature of the candidate in the admission ticket at Exhibit P1 with that of the signature of the candidate in the proforma at Exhibit P2A. However, the alleged signatures of the candidates should have been referred to handwriting expert before concluding that there was impersonation of accused number 2 by accused number 1. On the said point, the very evidence of PW1, the chief superintendent, itself gives an answer. When the said witness has stated that since the accused number 1 was caught red-handed, the question of getting a statement written by him as per Exhibit P7 or disputing the variations in the signature does not arise. Therefore, even after assuming that there is no much variation between the signature of the alleged student in Exhibit P1 to that of Exhibit P2A, still the very case of the prosecution, since is based upon catching hold of alleged personating accused red-handedly at the time of commission of the alleged offense, the non-referring of the alleged signatures to handwriting expert becomes too minor. As such, it goes to background. Lastly, the last point of argument of learned counsel for the petitioner was that the complaint as well as FIR So also the alleged statement of the person personating accused number 2, which is at exhibit P7, shows the name of the personating person as Prakash, son of Ramaya. Prakash, son of Ramaya. ಅದು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಬರೀತೀರಿ ಸ್ಪೆಲ್ಲಿಂಗು ಹೇಗಾದ್ರೂ ಓದ್ತೀವಿ. ರಮಯ್ಯ ಬರ್ಬೇಡಿ, ರಮಯ್ಯನಾದ್ರೂ ಮಾಡಲಿ, ರಾಮಯ್ಯನಾದ್ರೂ ಮಾಡಲಿ, ರಮಯ್ಯ. Whereas the person who was tried, convicted, and is present before this court as a petitioner in the present petitioner is not said Prakash, son of Ramaya, but it is one said Prashant Kumar, son of Pandurangaya. As such, also the case of prosecution should have been disbelieved by the court, disbelieved by the trial court as well the session judges court. The said argument of the learned counsel for the petitioner is also not acceptable for the following reasons. Small Roman 1. The very complaint as well the evidence of PW1 was that at the time of examination, in the place of genuine student by name Sri G.T. Chandrasekhara, some other person was writing the examination, and that the said some other person was caught red-handed. According to PW1, the chief superintendent of the center, and who is also the complainant in the case, when she inquired that fake student who was writing the answer paper on behalf of Sri G.T. Chandrasekhara, the said person identified himself as Prakasha. As Prakasha. The said statement that she came to know about the identity of the accused, number 1, as revealed by him at his inquiry in the examination center, has not been specifically denied or disputed from the accused side. Thus, in the examination hall at that time, except ascertaining the details of the alleged fake candidate by making an inquiry with himself, the chief superintendent of examination center would have no other material to ascertain his true or genuine identity. Furthermore, the matter was immediately required to be attended to, including lodging the complaint with the police if decided so. Thus, PW1 has stated that after such an inquiry, she got a statement of the said person also, which is at exhibit P7, wherein he himself has identified as Prakasha, son of Ramaya. Prakasha, son of Ramaya, which has led her to lodge the complaint before the police as per exhibit P3, showing the name of the alleged fake student, bracket accused number 1, as Prakasha only, but not with his actual name Prashant Kumar, which was revealed, which is said to have been revealed at a later stage. Small Roman 2. Even though the complaint and FIR was registered and lodged in showing the accused number 1 as Prakasha, however, the charge sheet has been filed showing the name of the accused, number 1, as Prashanta Kumara, son of Pandurangaya, aged 18 years. And accused number 2 as GT Chandrasekhara, son of GC Topaya. Thus, during the investigation, the correct and true name of the alleged fake candidate, who was said to have identified himself wrongly as Prakasha, was also noticed by the investigating officer. As such, the charge sheet came to be filed against the true person who is alleged to have personated accused number 2 in the examination. 3, small Roman 3. The evidence of PW1 that accused number 2, GT Chandrasekhara, was her student in government high school, Chikanayakanahalli, where she was working as headmistress, is an undisputed fact. In fact, from the accused side, a suggestion was made to her, suggesting that while the accused number 2 was her student in the said high school, he committed some mischievous act. As such, his parents, mischievous act, and that she had, as such, she had taken action against him, in which connection the parents of said GT Chandrasekhar, bracket accused number 2, had approached her and had made some objected to her and created some nuisance. It is in the said revenge, the headmistress, that is PW1, being the chief superintendent of the examination, had made a false case against the accused. Sapyara, without number. Thus, by making the said suggestion to the witness, the accused have admitted that PW1 was the teacher of accused number 2, Chandrasekhara, and she was very much acquainted with said accused number 2, Chandrasekhara. As such, there was no reason for her in wrongly identifying or misidentifying said Chandrasekhara with anybody else. Undisputedly, it is she who, after coming to know that somebody else is writing answer paper on behalf of said Chandrasekhara, visited the room and saw accused number 1 writing the examination personating her original student, Chandrasekhara, and caught him red-handed. As such, rather than PW1 identifying accused number 1 as Prakasha, till she lodged her complaint, she had already noticed that the person who was writing the examination was a different person than her original and actual student, Sri G.T. Chandrasekhara, that is accused number 2. As such also, she had every reason to believe the identity of accused number 1 as revealed by him at the time and place of incident, rather than ascertaining the correctness of his alleged identity. Therefore, PW1 has identified the accused properly, the court also, as the original candidate and another one as the fake candidate who had personated the original candidate, bracket accused number 2. Roman 3, therefore, for Roman 4. PW2, who is admittedly a teacher of accused number 2, who has taught accused number 2 for 2 to 3 years, and who incidentally was also assistant superintendent of examination center on the date of incident and witnessed the inquiry that was being held in connection with accused number 2 being personated by another person in the examination room, has also identified both the accused in the court as as accused number 1 as the person who was personating accused number 2, and accused number 2 as the genuine candidate who was supposed to and expected to write the said examination. The said identification by none else than the teacher who has taught the genuine student, that is accused number 2, for years, and who has identified both the genuine student and the fake student in the court, and which identification has not been denied, would clearly go to show that even though the name of the alleged fake candidate is shown as Prakasha in the complaint, but it was the accused number 1 who was identified in the court by accused number 2, who has written the examination answer paper personating accused number 2. Personating accused number 2. Fifthly, fifth point, PW1, not only the headmistress of the school where accused number 2 was the student and obtained admission ticket issued by her, but also as the chief superintendent of the center, has stated clearly and categorically that prior to the examination, she had issued admission ticket to accused number 2, the true student, by putting her signature on the photograph of the true student affixed upon the admission ticket at exhibit P1. She has stated in her evidence that the said photograph was substituted with the photograph of accused number 1, who was writing the examination on the said date in the place of accused number 2. The said evidence would clearly go to show at the end country sentence, previous sentence, she has issued examination admission ticket
accused number 2, the true student, by putting her signature on the photograph of the true student affixed upon the admission ticket at exhibit P1. She has stated in her evidence that the said photograph was substituted with the photograph of accused number 1, who was writing the examination.
This clearly go to show and establish that which candidate she has seen in the room writing the answer paper on behalf of accused number 2 was the one whose photograph was substituted in the admission ticket at exhibit P1. And that candidate is none else than accused number 1 in the court. Sixth point. The evidence of PW1 that admission tickets issued by the headmasters of the school, including herself, to the students would be affixing the rubber stamp of the school both on the admission ticket and the photograph, and putting the signature of the headmaster oblique headmistress both on the admission ticket, on the photograph affixed on the admission ticket. In the instant case, though PW1 as a headmistress who has issued the admission ticket at exhibit P1 has identified her signature at exhibit P1A on the admission ticket, but she has not noticed any signature. She has not noticed her signature on the photograph affixed upon the said admission ticket. A look at the said admission ticket also shows that, except a rubber stamp of the headmaster of the school, there is nothing on the photograph, much less the signature of the headmistress of the school. According to PW1, even the rubber stamp affixed on the said photograph is also not the original rubber stamp of her school, and it varies from the impression of the rubber stamp put on the admission ticket at exhibit P1. This further strengthens the case of prosecution and establishes that the photograph on exhibit P1 admission ticket was substituted by accused number 1 by affixing his photograph to the top, the original photograph of accused number 2, and he wrote the examination personating accused number 2. As such, it is for the above reasons. During the inquiry, it is stated that during the course of inquiry, the true identity of accused number 1 was revealed, which was not Prakasha, son of Ramaya, but it was Prashant Kumar, son of Pandurangaya. In that regard, though PW3, the room supervisor, is said to have given her statement before the investigating officer as per exhibit P10, but she has disowned the same. However, the investigating officer, as PW7 has stated that he has recorded the statement of PW3, Annapurnamma, and she has given her statement as per exhibit P10. Thus, it also stands established that the accused number 1, at the first instance, when he was caught red-handed, had given his false identity, stating himself to be a Prakasha, son of Ramaya, but the investigation revealed that he was Prashant Kumar, son of Pandurangaya, that is accused number 1. As such, the last point of argument of learned counsel for the petitioner regarding the alleged discrepancy in the identification of accused number 1 is also not acceptable. On the other hand, the evidence of PW1, the evidence of prosecution witnesses, more particularly PW1, PW2, PW3 to some extent, and PW7 and PW8, would clearly go to establish beyond reasonable doubt that the present petitioner, as accused number 1, has personated accused number 2, G.T. Chandrasekhara, and attempted to write Science 2 examination paper in SSLC examination on 13/7/2000 and was caught red-handed. It is appreciating these aspects, though not in such a detail, since both the trial court and the session judges court have rightly held the accused guilty of the alleged offense and sentenced him proportionate to the gravity of the proven guilt. I do not find any reason to interfere in it. Accordingly, the revision petition stands dismissed as devoid of merit. Registry to transmit a copy of this judgment to the concerned trial court and the session judges court immediately to enable them to do needful in the matter. Nodri, ಈಗ ನಿಮ್ಮ ಬತ್ತಳಿಕೆ ಅಸ್ತ್ರ, I cannot improve the case, what is there in the evidence, ಅವೆಲ್ಲವೂ ಬರ್ತಾವ? ಬರಲ್ಲ. Argumentative skill, advocacy lies here. Everything has to be read, how that has to be analyzed, how it has to be placed before the court. ಈಗ ನೀವು ಮಾಡೋದಷ್ಟು ಕೆಲಸ ನಾನು ಮಾಡಿದೆ. ನಾನು ಇದರಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರೆಸಬಹುದಿತ್ತು. Though in the above context, the assistance from the learned High Court government pleader was expected to at least to some minimum required quality. It is very unfortunate that I could not get any such assistance ಅಂತ. ಅದರದ್ದು ರಿಪರ್ಕಷನ್ಸ್ ಬಹಳ ಆಗ್ತದೆ. ಹೀಗಿರ್ತದೆ. ಸ್ವಲ್ಪ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು. ಅದಕ್ಕೆ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ತಾ ಇದ್ದೆ, ನೀವಿದ್ದಾಗಲೂ ಹೇಳ್ತಾ ಇದ್ದೆ, A4 ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಸೈಜ್ ನಲ್ಲಿ 8 ಪಾಯಿಂಟ್ಗಳು ನಿಮ್ಮ ಬತ್ತಳಿಕೆಯಲ್ಲಿ ಇರ್ತಾವೆ. ಅದೇ ಅಸ್ತ್ರಗಳು. Non-examination of investigating officer is not always fatal to the case of prosecution when the other witnesses have stated. Astra 1. Astra 2. A delayed examination of the statement of an eyewitness is not always fatal to the case of prosecution when it shows no prejudice caused to the accused. Astra 3. Any minor variations or discrepancies would not come in the way of the prosecution proving the alleged guilt against the accused. ಈ ರೀತಿ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಫಾರ್ಮ್ಯಾಟ್ಗಳು ಏನಿದೆ. ಆಮೇಲೆ ಒಂದು ಜನರಲ್ ಡಿಫೆನ್ಸ್. Sir, I am in revision, I am in appeal, I cannot improve any other case. What is there? Probably my counterpart in the trial court might have not conducted the case properly. Therefore, how I can improve the case? ಆ ವರ್ಡ್ ಯಾರೇ ಹೇಳಿ, ನನ್ನ ಎದುರು ಕೆಲವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗಳು ಹೇಳ್ತಾರೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗೋರು ನನ್ನ ಎದುರು ಹೇಳ್ತಾರೆ, ನನಗೆ ಮೈ ನಕಾಶಿಕ ಅಂತ ಉರ್ದು ಹೋಗಿ ಬಿಡ್ತದೆ. ನೀವು ಕೇಸನ್ನು ಇಂಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಯಾಕಾಗಿದ್ದೀರಿ? ನೀವು ಕೇಸನ್ನು ಇಂಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾಕಾಗಿದ್ದೀರಿ? ನೀವು ಕೇಸನ್ನು ಇಂಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾಕಾಗಿದ್ದೀರಿ? SPP ಯಾಕಾಗಿದ್ದೀರಿ? ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಯಾಕಾಗಿದ್ದೀರಿ ಅಂತ ಕೇಳುವ ಅನ್ನೋದು ನಾಲ್ಗೆ ತುದಿಗೆ ಬರ್ತದೆ. ದ ಸ್ಕಿಲ್ ಆಫ್ ಅಡ್ವೊಕೇಸಿ ಲೈಸ್ ದಿ. ಸ್ವಾಮಿ ಐ ಕೆನಾಟ್ ಇಂಪ್ರೂವ್ ಮೈ ಕೇಸ್ ಅಂತ ಹೇಳಿ ಉತ್ತರ ಕುಮಾರ್ ಅಂತರ ಬತ್ತಳಿಕೆ ದಿಲ್ಲು ಬಾಣ ಇಟ್ಟು ಓಡಿ ಹೋಗೋದಲ್ಲ. ಇರುವ ಅಸ್ತ್ರಗಳಲ್ಲಿ ನಾನು ಶತ್ರುಗಳನ್ನ ಹೇಗೆ ಬಗ್ಗು ಬಡಿತೇನೆ, ಅದಕ್ಕೆ ಏನು ಸೂತ್ರಗಳನ್ನ ನಾನು ಹೆಣಿತೇನೆ, ಅದು ಮುಖ್ಯ. ಈಗ ನೋಡಿ, ಅಷ್ಟು ಪಾಯಿಂಟ್ಸ್, ಅಷ್ಟು ರೀಸನ್ಸ್ ಇತ್ತಲ್ವೇ ನಿಮಗೆ? ಆ ಪಾರ್ಟಿ ಅಂತ ಗನಂದಾರಿ ಪಾಯಿಂಟ್ಗಳಿದೆ. ಈತ ನನ್ನ ಸ್ಟೂಡೆಂಟ್, ನನ್ನ ಹತ್ರ ಪಾಠ ಹೇಳಿಸ್ಕೊಂಡಿದ್ದಾನೆ, ಪರೀಕ್ಷೆ ಬರೆದವನು ಅವನಲ್ಲ, ಅವನು ನಾನೇ ಕಣ್ಣಾರೆ ನೋಡಿದ್ದೇನೆ ಅಂತನೂ ಹೇಳಿದ್ದಾರೆ. ಯಾವುದು ಗಮನಿಸಲಿಲ್ಲ ನೀವು. ಯಾಕೆ ಅಂದ್ರೆ ನಿಮಗೆ ರೆಡಿಮೇಡ್ ಈ 8 ಪಾಯಿಂಟ್ಗಳು ಹೇಳಿದ್ನಲ್ಲ, ಆ ರೆಡಿಮೇಡ್ 8 ಪಾಯಿಂಟ್ ನಿಮ್ಮ ಬತ್ತಳಿಕೆಯಲ್ಲಿ ಇರ್ತದೆ. ಉಳಿದಿರೋ 48 ಜನ ಲಾರ್ಡ್ಶಿಪ್ಗಳು ಅದನ್ನು ಒಪ್ಪಬಹುದು, ನಾನು ಒಪ್ಪಲ್ಲ. ನನ್ನಲ್ಲಿ ಪ್ರತಿ ಮ್ಯಾಟರ್, ಪ್ರತಿ ಕೇಸು, ಇಟ್ ಈಸ್ ಅನ್ ಎಕ್ಸಾಮಿನೇಷನ್ between me and the other side. I also write the examination paper. I expect them also to write the examination. Evaluation of the answers would be in the form of the judgment. In the form of the judgment. ನೀವೇನೋ ಹೇಳಿ ಕೇಳಿಸ್ಕೊಂಡು, ಅವರೇನೋ ಹೇಳಿ ಕೇಳಿಸ್ಕೊಂಡು 1.5 ಪೇಜು, 2 ಪೇಜು, 3 ಪೇಜ್ನಲ್ಲಿ ನಾನು ಬರೆಯೋನಲ್ಲ. ಎಲ್ಲಾ ಪಾಯಿಂಟ್ಗಳು ಬರಬೇಕು, ಎಲ್ಲದಕ್ಕೂ ರೀಸನ್ಗಳು ಬರಬೇಕು. ಅದನ್ನು ಹುಡುಕಿ ನೋಡಿ ಹೇಗೆ ಅಂತ ಹೇಳಿ ಬರೀಬೇಕು. ಹುಡುಕಿ ನೋಡಿನಿ. ಕಳೆದ 22 ವರ್ಷದಲ್ಲಿ ನನ್ನ ಎಷ್ಟು ಜಜ್ಮೆಂಟ್ಗಳು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ ಅಂತ. ಬೆರಳಿನಲ್ಲಿ ಎಣಿಸ್ಬೋದು, 2-3, ಜಾಸ್ತಿ ಇಲ್ಲ. ಅದು ಸಾಧನೆ ಇಲ್ಲ. ದಟ್ ಇಸ್ ಮೈ ಡ್ಯೂಟಿ ಆಸ್ ಎ ಜಡ್ಜ್. ಐ ಆಮ್ ಸಪೋಸ್ ಟು ಅಪ್ಲೈ ಮೈ ಮೈಂಡ್ ಸೋ ಡೀಪ್ and write my judgment. Otherwise, I am unfit to become a judge. I am doing my duty. I expect a proper cooperation from the prosecution also. So, homework ಬೇಕು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ. ಹಾ ಹೇಳಿ. ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಈಗ ಆಗಿದೆ ಎಷ್ಟು? ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ರೀ.
My colleague requested for password not I am seeking for the suspension of sentence not 138.
ನಿಮ್ಮ ಕಲೀಗ್ ಯಾರಿದ್ದಾರೆ ಅವ್ರಿಗೆ ನೀವೇನಾದ್ರು ಆನರೋರಿಯಂ ಕೊಡೋದಾಗಿದ್ರೆ ಆನರೋರಿಯಂ ಕೊಡಬೇಡಿ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಮ ಕಲೀಗ್ ಇಲ್ಲಿ ಇರ್ಲಿಲ್ಲ, ಇನ್ನೊಬ್ಬರು ಒಂದು ಟೈಮ್ ತಗೊಂಡು ಹೋಗಿ. An specific request for adjournment was made. Granted.
ಏನು ಪ್ರಾಸಿಕ್ಯೂಟರ್ಗೆ ಬೆಂಡ್ ಹತ್ತಿ ಬಿಟ್ರಂತ
Court officer. Court officer. Court officer. Court officer.
Number two. Number two also.
Court officer.
Karnataka Procedural. Central. Case of the central procedural.
Court officer. Court officer ಅವರೇ.
ಹೇಳಿ ಸರ್.
ಅದು ರೀಚ್ ಆಗದೆ ಹೋಗಿದ್ದು ಯಾವ ಬರುತ್ತೆ ಅದು?
ಯಾವ್ದು ಸರ್?
ಇಲ್ಲ ಏನಾದ್ರು ರೀಚ್ ಆಗದೆ ಹೋದ್ರೆ ಯಾವ ಬರುತ್ತೆ?
ಸರ್ ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ನಾಳೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಅಲ್ಲ ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಅಲ್ಲ ರೀಚ್ ಆಗದೆ ಹೋಗಿದ್ ಮ್ಯಾಟರ್ ಇವತ್ತು ರೀಚ್ ಆಗದೆ ಹೋದ್ರೆ
ಇದು ಸಾಹೇಬ್ರ ಡೈರೆಕ್ಷನ್ಸ್ ಸರ್.
ಹೌದಾ?
ಸಾಹೇಬ್ರು ಹೆಂಗ್ ಹೇಳಿದ್ರೆ ಹಂಗೆ.
ಹಾ ಓಕೆ.
All matters. All matters, serial number 21, Dharampal, D. Bhuneshwari, Srimati D. Bhuneshwari. Gopal. All the parties. Gopal. Gopal.
Have you compromised the matter? What are the terms, for what term you have agreed?
How much I have received now? Have you received any amount now? Remaining amount 1,75,000. Have you agreed to get it released in your favor in the trial court? You have no objection to acquit him of the alleged offence? Credit cost. The sum and substance of the joint application, as well as the affidavit of the petition, is that both parties to the revision petition have settled the matter amicably. Petitioner has handed over a demand draft number 070383 dated 2/8/2022 for rupees 1 lakh drawn on Axis Bank Limited, Kalyananagar branch, Bengaluru, in favor of the respondent. And it has no objection for the respondent to withdraw the amount of rupees 1,75,000 deposited by him the CC number 50075/2013.
I'm sorry, my lord. Observe 755 instead of 25.
ಹೇಳಿಲ್ವ ಬೆಳಗ್ಗೆ ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದೀರಿ ನೀವು ಅಂತ
ಮನಸ್ಸಿಗಾಯ್ತ ಕ್ವಶನ್
ಸಿಗ್ನೇಚರ್ Number 50025/2013 in the court of 14th edition CMM at Mayo Hall, Bengaluru. Have you received the demand draft for rupees 1 lakh? You have received. The respondent, who is physically present and identified by the learned counsel for the respondent, acknowledges the receipt of the above said demand draft of rupees 1 lakh by her from the petitioner. The petitioner, through his counsel, submits that he would extend all assistance and execute the necessary papers, applications, etc., letter, etc., to enable the present respondent to withdraw the amount of rupees 1,75,000 said to have been deposited by him in the trial court without causing any inconvenience to the respondent. The inquiry made with the parties physically adannella haki demand graded cost and haki demand draft number haki
ಆಮೇಲೆ acquittal. Fine, you stand acquitted, you can go.
Serial number 37. VR Balraj, Sri SN Mahesh.
Called again in the fourth round. None appear in the matter, either physically or through video. No reasons are forthcoming for non-appearance of the learned counsel from both. The result of the order sheet is due to show. Along back as on 15/12/2018. The learned counsel from both sides had made submission that the matter has been settled between the parties and that they have filed an application reporting settlement. History was directed to verify the application and place the application for consideration. However, the registry wide its office note at 37/22. That is 3.5 years after the order dated 15/12/2018 made its submission that no such application has been filed so far by the parties. Thereafter, the matter was listed on 3/8/2022, on which day there was no representation from the petitioner's side. Again, on 15/9/22 also, the current counsel from both sides have remained absent. Thereafter, the matter, when is taken up today in 3 rounds, there is no representative from either side. We clearly go to show that the petitioner is not interested in prosecuting this criminal revision petition, which is filed by him challenging confirmation of his conviction. That is punishable under section 138 of negotiation. No fear. The revision petition stands dismissal for.
Serial number 41. Sri Prabhupada B. Tumbagi, Sri S. Shekhar Shetty.
You cannot take other side learned senior counsel also for granted. Since morning he is waiting. Even the court noticed that, and court say on the lighter side observed him that say he has now accrued with the right to send bill to your senior counsel. Factually, your senior has already completed his argument. When the court was about to hear his side of argument, he said that he would make his submission on couple of citations. Sir, in my court, merely because an advocate is a designated senior counsel, he cannot expect extraordinary relaxation. I grant relaxation. I do respect extra, but not at the cost of making another designated senior counsel waiting for the whole day. I can wait from morning till evening. I will be here. Whether you come at 10:30 or whether you come at 3:30, it doesn't make generally no much inconvenience to me. But we should respect the precious time of the other side learned senior counsels also. ಏನ್ ಹೇಳ್ತೀರಿ? Or 5 minutes in ತಗೊಳ್ತೇನೆ ಅನ್ನೋ ಗ್ಯಾರಂಟಿ ಇಲ್ಲ. ನಾನು ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೇನೆ. Both of you have to wait. When it comes again, the next turn, first round, second round, third round ಅಂತ ಬರ್ತದೆ. ಇದೀಗ now I am in the fourth round. Called again in the afternoon. Called again in the afternoon. Learned junior counsel for the petitioner physically present and stating that his senior counsel is on his legs in another court hall. Praise for pass over in the matter. ಅದೇ ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಕರಿತಾ ಆರ್ಡರ್ ಶೀಟ್ ಫಸ್ಟ್ ಕೊಡಿ. ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರೆ ನಿಮಗೆ ಯಾಕೆ ಇಟ್ಕೊಳ್ತೀರಿ? ನೀವು ಅಲ್ಲಿ ಎಷ್ಟು ಸತಿ ಹೇಳಿದ್ರು? This matter was taken up this morning when the learned counsel from the petitioner's side had remained absent. As such, the court on its own passed over the matter. The learned senior counsel for the respondent along with his instructing counsel was present both in the morning session and now. The learned counsel for the petitioner, since once again is asking for a pass over. The learned senior counsel for the respondent, who has been waiting in this matter since morning, submits that the matter be taken up on 15/10. Accordingly, list the matter on 15/10. Yes, next.
Serial number 43. K. Shashikumar.
Learned counsel for the petitioner, neither present physically nor through video conference. Your amicus curiae for the respondent alone is physically present. The
Revision petition is of the year 2013, which in turn has arisen from a criminal case of the year 2010. As such, the matter is of 12 years old. The respondent is being represented by learned amicus curiae. Thus, in such an old matter, the learned counsel for the revision petitioner has remained absent. As such, though the petition could have been dismissed for non-prosecution, however, in the best interest of justice, one more opportunity is being granted to the petitioner to appear and proceed further in the matter. Hence, list the matter on which day would be convenient to you? 15, 18, 19. Is the matter on 19, 10, 2022. It is made clear that in case the learned counsels from both sides fail to appear on the said day, the court may proceed to pass appropriate orders. Yes, next.
Serial number 45, HB Chandrasekhar.
On record is not feeling well enough. Instructed me to prefer an adjournment.
Learned proxy counsel for the revision petitioner is present and stating that the learned counsel for the petitioner on record is not feeling well. Pray for a short accommodation. Learned CH-8 for the respondent is physically present. The perusal of the next one. Case file would go to show that present revision petition has been filed in the year 2013 by the present petitioners, challenging an order of allowing of application under section 319 CRPC filed by the state of the prosecution in the session judges court in SC number 38 of the 2011, while its order dated 2/2/2013. Present petitioners are included accused number 4, 5, and 6 respectively. In the sessions case, wherein the charge sheet has been filed for the offences punishable under section 363, 302, 201, the read section 34 of Indian Penal Code. The present petitioner themselves have filed an application again 1/2015 under section 482 CRPC, taking an early hearing of the matter. In spite of the same, the perusal of the order sheet would go to show that the learned counsel for the petitioner himself has remained absent continuously from 15/12/2018 till date. Several days of hearing has been passed by after 15/12/2018 till date, including on 5/3/2022, 21/3/2022, 1/4/2022, 24/2022, 28/7/2022. Thus, even after filing an application for early hearing and getting it pending without any further progress, the counsel for the petitioner has remained absent. Consequently, the trial in the session judges court also might have been stalled, since the impleading of the present petitioners in the said sessions case has been challenged in this revision petition. It is nothing but it appears that the same would be one of the tactics of getting the matter adjourned and ensuring the delay in the trial in the sessions court, so that the witness, the memory of the witness, charge sheet witnesses would be faded, or the witness may no more be available easily to the prosecution. Hence, I am of the view that it's a fit case where an amicus curiae be appointed, which was already, which called a caution in which regard was already given to the petitioner by making observation in this matter on 21/3/2022. Accordingly, the learned counsel,
one submission, my lord.
no interference, please. You are a proxy counsel. You have done your duty. No, wait. Tumbige tagaltirenri.
One more.
319.
One more.
Accordingly, learned counsel 3.
One more
Prabhu
instruction
Gowda
shall
Tumbagi.
be given, my lord. My lord, one more instruction.
Don't interfere, please.
One submission.
Accordingly, learned counsel Sri Prabhu Gowda Tumbagi is appointed, who is physically present in the court, is appointed as amicus curiae in this matter. The learned counsel takes notice for the petitioner as an amicus curiae in the matter.
That's only one
The
submission.
registry is directed to furnish the learned amicus curiae the entire set of a copy of the entire set of the memorandum of revision petition, the impugned order, and the copies of the all other available documents, including copies if you request for any documents from the sessions court record. But immediately and without delay,
but not later than 3 days from today and free of cost. This is the matter on 19/10.
More submission, my lords. He has given instruction that, my lords.
In view of appointment of amicus curiae for the petitioner, the existing counsel for the petitioner stands relieved from appearing for the petitioner in this matter.
Serial number 46, MH Saukar, respondent is CGP.
I appear for the petition in the above case. The offence alleged is under section 504, 332, 186, 353 and 506. Initially the complaint filed by the side, it has been allowed by the in CC number 295/2010 on 7/2012, against which an appeal was preferred by the accused herein. In 13/12 of on 3/2/2013, my lord, it has been dismissed, against which revision is being prepared by the accused. My lord, in this case, my lord, accused is
1 minute.
Please, my lord, please.
1 minute.
Please, my lord.
Yes, please.
Accused is a social worker in the village, madam. Normally, in the villages, madam, some people belong to an agriculture school and all. They used to tell him to get some birth certificate in the school, and also sometimes the living certificate in the school, and also with regard to the midday meal also, madam, Nadi Kali and there is Sumatsara school hokta irtare. He was frequently goes in order to get certain work by the villagers there. those who are all agriculturists go to they enter certain works to him. He goes to the school, and my lord, one day he went to the school there. The headmaster was there in the school, my lord. He immediately, the headmaster started that, my lord. He started, according to the complaint, my lord, he started questioning the students with regard to the education, with regard to the Nalikali annadu ಒಂದು ಇದರಲ್ಲಿ subject. ಅದಕ್ಕೆ ಅವರು headmaster says that no, you are not supposed to ask these questions. ಅದು ವಿಷಯನೇ ಬೇರೆ, ಇದೇ ವಿಷಯ ಬೇರೆ ನೀವು ಹಾಗೆ. ಆಮೇಲೆ he started visiting another teachers there also, my lord. There also they were ನೀವು ಯಾರು, whom you are, what are your rights with regard to this? He said that people have entrusted me to get certain works done with regard to the school living certificate and all that. That is why I visited. With regard to this matter, also this SDMC midday meal ಅಂತ ಅಲ್ಲಿ ಸಾಕಷ್ಟು several complaints were also there. He was looking, he used to visit the schools and also to verify all these things, certain complaints and all. ಇದನ್ನ ಒಂದು ಅವ್ರ ಆಧಾರವಾಗಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು frequently started visiting ಅಂತ ಹೇಳ್ಬಿಟ್ಟು the school authorities themselves, though there was not much disturbance by he went and asked certain documents also by the school authorities. They did not show him. There is that he has thrown away the attendance list ಎಲ್ಲ ಇದನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಹರಿದು ಹಾಕಿದ್ದಾರೆ. ಆಮೇಲೆ he has made an attempt also to the headmaster to beat him, and that is what the complaint by this. The headmaster has thereafter has given a complaint to the station, and they have registered a case against the accused herein. Trial went on, my lord. In this case, all the witnesses are also the school authorities, my lord. They are all teachers of the school, and also except one of the cook there, midday meal although they actually denied this thing. I have not seen this anteli. But SDMC chairman anta school ಒಬ್ಬ ಇದು ಇರ್ತಾರೆ ಅವರು. He said that no, when I come before the school, I have not seen anything that has been happened at all anteli. In order to check this man, my lord, they have seen that something is to be foisted against this man, and they have made to bring him under the criminal activities, and they have filed a complaint against these offences, saying that he is obstructing the public servants with regard to these duties and all. His main intention was only that, my lord. He is a youngster. He normally the peoples in the village sometimes what they say is meant one of the certificates which he went and asked. They say, man, the other side says, no, this is not the certificate with religion. You say that I wanted to certificate, living certificate of my relative. Thereafter in the inquiry, it is found that he is not a relative. He is not a relative. That is the only this thing. They said that whatever the version you have taken, it is contrary to that. The trial court has also convicted him, and the appellate court is also convicted him. Against this revision is being preferred. Then an innocent person, my lord, because he normally visits all the time the schools with regard to the inquiry, with regard to the so many in the villages. He is a social worker and also. Not with given the avakasha kottravage, he will also, of course, the incident, it has been bloated. Of course, he went there and asked these things. It has got annoyed with the school teachers and also the headmasters. It has ended in this thing, in filing a complaint against this person. It's a first time offender also, first time. Also, your lordship kindly. ಎಲ್ಲ witnesses, ಎಲ್ಲ school teachers, all of them are school teachers, all of them are teachers, except one cook, and also the Majer which has been done is also been not supported. They have also denied that. Majer is also not proved. Majer is also not proved. It is not that petitioner is not saying that he is not gone there or anything, but it is bloated up. They wanted to see something against this petitioner and to see that he should be totally cut from. He is a social worker. He many times in the villages they ask him, because he takes up these things to the schools. Normally, with regard to the birth certificate, living certificate, ನಲಿ ಕಲಿ ಅಂತೇಳಿ ಗವರ್ಮೆಂಟ್ನವ್ರದ್ದು ಏನೋ ಒಂದು ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ, ಅದರಲ್ಲಿ ಪಾಠ ಹೇಳೋದಿರುತ್ತೆ. ಇದರಲ್ಲಿ ಹೋಗಿ ಕೇಳಿದಾನೆ ಹುಡುಗರಿಗೆಲ್ಲ, ಈ ತರ ಹಿಂಗಾಗಿ ಅಂತ. ನೋ ದೀಸ್ ಆರ್ ನಾಟ್ ದಿ ಕ್ವಶನ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ಆಸ್ಕ್ ಇನ್ ದಿ ನಲಿ ಕಲಿ ಅಂತೇಳಿ ಗಲಾಟೆ ಮಾಡಿ ನೀವು ಹೊರಗೆ ಹೋಗು ಅಂತ ಹೇಳಿದಾನೆ. ಇದಾಗಿದೆ. He admits, he admits he has gone to the school and all, but your lordship may kindly see that maybe a warning on him to see that such things should not. But all things are bloated with regard to the physical handling that has been denied by the even in the medical reporters also it is not. ಅವರು ಇದನ್ನ ಮಾಡಿದ್ರು, ಈ ಬಲಗಡೆ ಎದೆಗೆ ಒಂದು ಸ್ವಲ್ಪ ಇದಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ಇಟ್ ಇಸ್ ನಾಟ್ ಕ್ಲಿಯರ್ ಇದು. He has got a small child, now he has been admitted to the hospital also, about 3 years boy. A very rare this disease has been found by. He's under a very difficult situation also with regard to him. There was no intention on his part. There was no intention at all, except that whatever the people say in the villages, he used to. Of course, there may be some while going and inquiring with this, it is being bloated up in order to see that this man should be. Even also now the headmaster also says that he will come before the court if necessary. He will come and that is what happened.
Yes, Mr.
As a accused are 504, 506, 353, 188 of IPC. The accused are committed for the said offence by virtue of order CC number 295 of 2009, wide order dated 7th February 2012. The incident is pertaining to 26/2/2010. On the said day, the accused has said to have visited the school and interfere with the duty of PW1 teacher, headmaster, and also has gone to the school where PW2 and 3 are taking the class. The case of the prosecution is rests upon the eyewitness. PW1 to 3 are the eyewitness, and the PW 9 and 10 are also the eyewitness. The students where the accused has gone to the class conducted by PW2 and 3 and interfere with the performance of the school class. My humble submission to this honorable court, the prosecution has adduced sufficient evidence through the cogent evidence of PW1 to 3 and 9 and 10 with regard to the interference caused by the accused during the school hours. To that effect, further PW7 doctor has issued an Exhibit P3 wound certificate in respect of the injury caused to PW1. The accused has taken the defense that he has gone for taking the birth certificate and he has led the evidence through DW1 and got marked the Exhibit D1. However, DW1 says that he has visited the school for getting the caste certificate and he has assigned the same duty to same work to accused. The evidence of DW1 was been in detail discussed and discarded by the learned trial judge with the proper reasoning. After appreciating the evidence on record, the evidence of PW1 to 3, the evidence of 9 and 10, and the doctor evidence, the learned trial judge has convicted the accused for the offence, charged offences, and accordingly, the accused has preferred criminal appeal. And the Honorable First Appellate Court reappreciated the entire evidence and confirmed the order of conviction passed by the trial court. This Honorable Court gives the purview about the reasoning given by the learned trial judge. So also the First Appellate Court, nothing contrary or any perversity is forthcoming in the judgment of the court below. Hence, my humble submission to this honorable court, the prosecution has established case beyond reasonable doubt. And as far as ಕೇಳಿಸ್ತಿಲ್ಲ ಸುಮ್ಮನೆ ಅವರು PO Act ಅಂತ ಹೇಳ್ದಂಗೆ ಒಂದು ಸ್ವಲ್ಪ ಕೇಳಿಸ್ತು. But the offense is against the school teacher, and that too during the course of execution of the official duty, the accused has interfered and caused disturbance to the official duty of PW1 and PW2 and 3. Considering the gravity of the offense, though they are the first time offenders, the accused is not entitled for relief under PO. Hence, I beg this honorable court to dismiss the petition and confirm the order passed by the court.
The case of the prosecution is the date 26/2/2010 at about 10:30 a.m. At government primary school in Ramanagara by CW1 Shekhar was on duty. Was on duty as a teacher, teaching the students. The accused entered the classroom and obstructed the teaching work of CW1. When his act was questioned, the accused abused CW1 in filthy language, tore the attendance book maintained by him. He also assaulted CW1 with his hands and threatened to his life. Thereby has committed the offences punishable under sentence. Paragraph 4, 186, 353, 506. IPC. The point for consideration. The counsel for the petitioner appearing through video conference. The argument submitted that the petitioner is a social worker and was frequently visiting the school and other public offices to get the work of the general public done, inclusive of obtaining date of birth certificate, death certificate, etc. The complainant was not liking the social work of the accused has filed a false complaint. The current counsel further submitted that all the witnesses are the teachers in the school and the member of the FDM committee, as such they are interested. Also submitted that the scene of offense Panchanama has not been supported by the Pancham. The trial court and the session judges court have ignored this aspect and proceeded to convict the accused for the alleged offense. With this, he prayed to allow the revision petition. For contrast, already HCGP appearing for the respondent state in his argument submitted that all the witnesses except the witnesses for scene of offense Panchanama have fully and clearly and uniformly case of prosecution. There is consistency in the evidence of all prosecution witnesses with beyond reasonable doubt go to prove the alleged guilt against the accused. He further submitted that the medical evidence of the doctor who treated the complainant also go to show that the accused has committed the alleged act. This is submitted that the accused having committed a serious act of obstructing the teachers who are the public servants in their official duty and threatening several of the teachers of direct consequences and committed offences does not deserve any lenience by this court. As such, the revision petition does not deserve to be allowed. Among the all witnesses examined by the prosecution, PW1 finds himself to be the injured complainant in the matter. PW2 to PW6 and PW8, PW9 are projected as eyewitnesses to the incident. PW7 shown as the medical doctor. He is said to have treated the injured and issued wound certificate as per exhibit 3.
PW 10 and PW 12, though projected as punch witnesses for scene of offense Panchanama, but neither of them have supported the case of prosecution. PW 11 is the investigating office on the first part. In addition to that, the accused also got examined one witness by name, Bob. And DW1. PW1, CW1, Shekhar. The evidence of PW1, CW1, Shekhar. PW2, CW4, Joshi Vinod. PW3, CW5, Kavita. PW5, CW7. That they were the teachers working at Ramanagar School, exhibit P1 Purvi. Working at Government Lower Primary School, Ramanagar. Among whom PW1 was the headmaster, not in this case. The evidence of PW4, CW6 that she was working in the said school as a cook since 9 years prior to the incident. And that and the evidence of PW5, CW7 turns out that PW4 got Hesaraki, Nurjan B and Hesaraki. Turns out that at the relevant point of time, he was the chairman of TMC of said school. And the evidence of PW6 that at the relevant point of time he was working in Ramanagara village as waterman is not in dispute. PW1, Shekhar has stated that on 26/2/2010 in the morning, at about 10:30 a.m., while he was teaching the students in the school, the accused barged into the classroom and started putting questions to the students. Though the children were giving the right answers, the accused objected to this. The accused did not agree to the same, and he insisted them to write the alphabetical letters in Kannada. When he, his witness, told the accused that the children are giving the correct answers, he asked the witness not to speak. Thereafter, he went to another room where another teacher was holding the class. under the concept of inverted comma nullity. Bracket nulli. We enjoy and learn. Close the bracket. There also, the accused started asking different questions to the children. The teacher there by name Kavita, when asked the accused to leave the classroom and questioned him as to how he had entered the classroom and who he is, the accused stated that he is the General Secretary of Youth Congress of Davangere District, and very shortly he is going to take oath as member of Legislative Council. The witness has further stated that apart from the above, the accused insisted for production of the school documents before him when he, bracket CW1, stated that without prior permission from the higher authorities, those documents cannot be shown to him. The accused shouted at him, stating that he is a people's representative. Stating so, he manhandled him, bracket his witness, and assaulted on his chest with his hand. Further, the accused took out the attendance book which was lying on the table and tore it down. He threatened the witness, bracket his witness, of getting him transferred and abused him in filthy language. He also threatened the accused of his life, threatened him, bracket, this witness, stating that would put an end to his life. However, when the other teachers and the cook rushed to the room, the accused left the place. The witness stated that CW4 to 10 rescued him from the attack by the accused. It is thereafter he went to the complaint police and lodged the complaint as per Exhibit P1. The witness also stated that the police drew a scene of offense panchonama in his presence as per Exhibit P2. The witness, apart from stating that the accused has obstructed in him discharging the public duty, has identified the accused in the court. The witness was subjected to a detailed cross-examination from the accused side, where the witness has adhered to his original version rather than demolishing or imbibing doubt in the statement of PW1 made in his examination chief. Some more details were elicited about the incident and the distance between the police station, hospital, and the place of incident, with the cross-examination of this witness. Suggestion made to the witness in the forum of a defense that since the accused demanded for issuance of a date of birth certificate of his relative, a false complaint has been lodged against him, was not admitted as true by this witness. PW2, PW4, Joshi Vinod, PW3, CW5, Kavita have also fallen in line of PW1 in supporting the case of prosecution. Both of them have stated that being teachers in the very same school while they were teaching in the classroom on the date of incident, the accused entered the classroom and started asking questions to the student. He started himself teaching the student, and even though the students answered correctly to his questions, he objected to the same. He compelled the students to write Kannada alphabets. When these two witnesses attempted to interfere and ask him as to what he was doing, he asked them to keep quiet, stating that he was the secretary of the Youth Congress Party the accused has continued his acts. Both the witnesses have further stated that the accused has committed a similar nuisance in the classroom of the headmaster, that is CW1, bracket PW1, wherein apart from threatening and assaulting the headmaster, he has also torn an attendance book maintained by the class and lying on the table in his classroom. Both these witnesses, even in their cross-examination, have adhered to their original version. An attempt made by the accused to check on the veracity in the evidence of PW2 and PW3 could not be successful. Cross-examination. PW4, CW6, Noor Janvi stated that as a cook while she was attending to her work in the school on the date of incident, the accused had come to their school and assaulted CW1 and obstructed CW4 and CW5 from discharging their duty as teachers. The witness has also stated that the accused has put a life threat to them and has stolen the attendance book. She stated that she was on duty as a cook on the said day in the school and has seen the occurrence of the incident. She has identified the accused in the court. Even she too has adhered to her original version in her cross-examination and given more details as to her routine as a cook in the school. PW5, PW7, Chaman Saab has stated that at the relevant point of time, that is in the year 2010, he was the chairman of SDMC of Ramnagar Government School. He knows the accused. On the date of incident, the accused had been to the school and was creating nuisance and was obstructing the work of the teachers. Hearing the noise caused by the accused, he went to the school and saw that the accused was abusing the teachers in filthy language and was manhandling CW1. It was him who had rescued CW1 and resolved the dispute. This witness also has identified the accused in the court. In his cross-examination, this witness also, Sapkara, adhered to his original version and denied a suggestion that the accused had been to the said school in order to collect the date of birth certificate in order to school confirmation letter. However, a false case has been filed against him. The witness has not admitted the said suggestion as to PW6, CW8, Najir Saab also has stated that he knows CW1, 4, 5 to 7. 7. On the date of incident, the accused had been to the government school in their village Ramanagara and was doing some and had caused some disturbance there. Hearing the noise of such disturbance, he visited the said school. Saw the accused was creating nuisance and was having altercation with CW1, 4 and 5. The witness has identified the accused in the court. denial suggestions made to him in his cross-examination were not admitted as true by this witness. PW8, Ms. Rian Bani, PW9, CW10, Ms. Rukshana Bani, both are minors claiming themselves to be of age 12 and 11 years respectively and the students in the same school. After court questions, the court thought that they can be examined as witnesses. Accordingly, the prosecution was permitted to examine them as witnesses. Both these witnesses have uniformly stated that they were the students studying in the said school, and on the date of incident, while they were in the classroom, the accused barged into their classroom and started teaching them of different subjects and asking them different questions. When CW1, their teacher, questioned the accused, he manhandled him, manhandled him, abused him, and assaulted him on his chest with hand. They have seen the incident. PW9 has further stated that apart from manhandling the teacher, apart from manhandling her teacher, the accused also put her teacher into life. Both the witnesses have identified the accused in the court. Thus, the evidence of all the above witnesses, who are all eyewitnesses to the incident, including the injured witnesses, have successfully withstood the cross-examination from the accused and have uniformly stated that on the date of alleged incident, having no valid reasons, accused barged into their school and created nuisance, created obstruction for the teachers in discharging their duty as teachers, and started himself handling the class in his own manner. It is further established from their evidence that when objected to by PW1, PW2, and PW3, the accused threatened them of their consequences, including life threat to PW1, and stated that he was an influential person, being the general secretary of a political party. So, PW1, in his evidence, have stated that he was in need of caste and income certificate. As such, he had been to the headmaster of his school. However, since the headmaster made him to roam around for a few days and asked to send him somebody else, he had requested the accused to go. To the sub school. Even after assuming that DW1 had requested the accused to go to the said school, still, a major discrepancy in the defense of the accused can be noticed. That is, at one place in the form of a suggestion made to PW1, accused has suggested to the witness that it was connection with collecting of date of birth certificate of his relative. He had been to the said school. However, the witness has not admitted the said suggestion as true. The very same accused has made another suggestion to PW5 in his cross-examination, suggesting to him that he wanted a school confirmation certificate, study confirmation certificate. As such, he had been to the said school. Said PW5 also has not admitted the said suggestion as. Whereas DW1 has stated that he wanted a cost and income certificate. As such, he had approached the headmaster of the school, and later at his request had sent, later at his request to send some other person, he had sent the accused. Thus, by making those suggestions, the accused has admitted that on the date of alleged incident, he had been to the said school. However, the alleged purpose of he visiting the said school varies in the form of his different, varies in its reason, as suggested to PW1, PW5, and stated by DW1 respectively. Thus, the very alleged purpose of the visit of the accused, since is at variance, and different suggestion is made to different witnesses, apart from DW1 also giving a different version about the reason for visiting the school, it is highly unbelievable that the accused had any specific purpose to visit the said school on the said day. On the other hand, the evidence of all the above mentioned eyewitnesses, more particularly PW1 as an injured witness, PW2 and 3 as the teachers in the very same school who were handling the school at that time, and PW4, PW5, PW6, PW8, and PW9 as the eyewitnesses to the alleged incident, clearly go to establish that having no valid reasons, the accused, probably thinking himself too high, as he claims that he was a general secretary of a political party, had visited the said school, had barged into the said school, and probably to show off that he is an influential person, has created the act stated by, alleged by the above said witnesses. The act of the accused in unauthorizedly entering the classroom, snatching the books from the teachers, tearing off the attendance book, putting several improper, unreasonable questions to the students, compelling the small students to write certain alphabets in a particular language, have all been uniformly stated by PW1, PW2, PW3, who are the teachers and the remaining eyewitnesses. Thus, the above evidence of the affected teacher, including the assaulted PW1 and the eyewitnesses, which has come uniformly, establishes beyond reasonable doubt that the accused on 26/2/2010 at about 10:30 a.m. has entered the Government Higher Primary School at Ramanagara village, obstructed PW1, PW2, PW3, who were the public servants from discharging their official duty as teachers, assaulted PW1 with his hand, abused the teachers in filthy language, and threatened them of dire consequences. The above said evidence of PW1, PW2, PW3, and other eyewitnesses that the accused assaulted PW1, their headmaster, is further corroborated by the medical evidence of the medical doctor, that is PW7, CW11, Dr. Suresh. The said witness has stated that being the medical officer of Community Health Center at Arsikere on 26/2/2010 in the evening at 7 o'clock, while he was on duty, he has examined Shekarappa, bracket PW1, who had been to him with the history of assault. After examining him, he noticed pain and swelling of right side of the chest of the patient. The doctor opined that the said injury was simple in its nature, in which connection he has issued a wound certificate, which the witness has identified at Exhibit P3. The suggestion made to him in his cross-examination that if a person falls from a staircase, sustains the similar injuries were not admitted as true by this witness. A similar suggestion was also made to PW1 from the accused side in his cross-examination. Which suggestion the said witness also has not admitted as true. Thus, an attempt made by the accused to show that the injuries sustained by PW1 was otherwise than the alleged act of he assaulting him could not be successful. Thus, the medical evidence also corroborates the evidence of eyewitnesses, more particularly of injured witness PW1, that accused had assaulted him on his chest, which has resulted in PW1 suffering pain and swelling of a portion of his chest. Thus, even the medical evidence also corroborates the case of prosecution, as well the evidence of all the eyewitnesses, including PW1. No doubt. Though the prosecution has examined PW10, CW so-and-so, Mohammed Rafiq, and PW12, CW so-and-so, Govindappa, showing them as the witness for scene of offense Panchanama as per Exhibit P2. And neither of them have supported the case of prosecution, but by their non-supporting of the Panchanama Exhibit P2 would not be fatal to the case of prosecution when all the material witnesses, including the injured and other eyewitnesses, have uniformly stated that the place of offense was their school, which is the Government Higher Primary School of Ramanagara village. They have specifically mentioned the classroom also, where the accused assaulted PW1 on his chest and barged into other two classrooms and snatched the books from the teacher and started handling the students in his own manner. Thus, when the evidences of material witnesses, including the eyewitnesses and the injured victim, have clearly stated about the scene of offense, and when accused also has not denied that he had visited the said school on the said date and time alleged in the charge, the mere non-support, the mere absence of support from PW10 and PW12, the alleged panchas to the scene of offense Panchanama, would not take away the case of, would not demolish the case of prosecution, or in no manner imbibe any doubt in the case of prosecution. Since it is appreciating and analyzing these facts, though in brevity, both the trial court and the session judges court have held the accused, have rightly held the accused guilty of the alleged offences, and the trial court has ordered the sentence proportionate to the gravity of the proven guilt. I do not find any reasons to interfere in the impugned judgments challenged in this revision petition. Accordingly, I proceed to pass the following order. The criminal revision petition stands dismissed as devoid of merits. Mundindala haki, the accused is directed to voluntarily surrender before the trial court within 45 days from today and suffer the sentence of imprisonment imposed by you. Registry to transmit.
प्रभु गौड़ भी तुम्हें
Tanker lorry dashed into a moped. One death, one injury.
Offense is not 279, 337, 338, 304. 279, not of 1,000 rupees fine, not default. 3 months. 337, not 500 rupees fine, and not default, not. It is not.
1 minute. Right? Why this judgment that trial court committed the accused for the alleged offense or not ಬಂದ್ರು ಮೇಲೆ ಹಿಂದೆ ಹೇಳ್ತಾ ಇಲ್ಲ
ಎಲ್ಲೂ ಹೇಳ
ಅಷ್ಟೇ ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದೆ.
ಕನ್ಫರ್ಮ್ ಮಾಡ್ತಾ ಇರೋದ್ರಿಂದ
Yes, please. 337.
337, 500 rupees fine, not default, not 338 also not 1,000 rupees fine, 100 rupees fine, default 3 months. 304 A, so 1 year.
So the advocate must be very influential or very strong in the trial court, say who could avoid the imprisonment in all other 3 offences, except 304A, which was inevitable for the court. ಅಷ್ಟೇ ಆಗ್ತದೆ. ಅದ್ರಲ್ಲಿ ಗುಟ್ಟೇನು ಸುಳ್ಳೇನು. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ, ಸಿವಿಲ್ ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಹೆಚ್ಚು ನಡೆಯೋದು ಅದೇ. ಯಾವ ವಕೀಲರು ಎಷ್ಟು ಜೋರ್ ಇದ್ದಾರೆ, ಎಷ್ಟು ಲೋಯೆಸ್ಟ್ ಪನಿಷ್ಮೆಂಟ್ ಸಾಧ್ಯನೋ ಅಷ್ಟೇ. 50 ರೂಪಾಯಿ ದಂಡ ಕಟ್ಟಿ ಹೋಗು, ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅನ್ನೋದಿಲ್ಲ. ತೀರಾ ಅನಿವಾರ್ಯ ಅಂದಾಗ ಮಾತ್ರ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಲೋಯೆಸ್ಟ್ ಲೆವೆಲ್ ಅಲ್ಲಿ. ನೋಡಿ 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 ಸಾಕಾಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬಹಳ ಸ್ಟ್ರಾಂಗ್ ಆಗಿ 4 ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಬರೀತು. ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅಂತ ಇರೋದು ಬರೀ ನೇಮ್ ಸೇಕಿಗೆ, ಡೆಕೋರೇಷನ್ ಗೆ ಅಲ್ಲ. ಇಟ್ ಯೂಸ್ ದಿ ವರ್ಡ್, ಇಟ್ ಇಸ್ ನಾಟ್ ಫಾರ್ ಡೆಕೋರಮ್. ನಾಟ್ ಫಾರ್ ಡೆಕೋರಮ್. ದೇರ್ ಮಸ್ಟ್ ಬಿ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಈವನ್ ಇನ್ ಪ್ರಿಸ್ಕ್ರೈಬಿಂಗ್ ದಿ ಸೆಂಟೆನ್ಸ್ ಆಲ್ಸೋ. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿ, ಸರ್ಕ್ಯುಲರ್, ಎ ಬೈಂಡಿಂಗ್ ಸರ್ಕ್ಯುಲರ್ ಅಪಾನ್ ಆಲ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನೀವು ಸೆಂಟೆನ್ಸ್ ಅಂದ್ರೆ ಮಿನಿಮಮ್ ಸೆಂಟೆನ್ಸ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕು, ಅದಕ್ಕಿಂತ ಕೆಳಗಡೆ ಹೋಗಬಾರ್ದು ಅಂತ. ಆದರೂ ಎಂದಿನಂತೆ ಆ ಸರ್ಕ್ಯುಲರ್ ಗಮನಕ್ಕೆ ಇಲ್ಲದೆಯೇ ಎಷ್ಟೋ ಜನಗಳಿಗೆ ಅಂತದೊಂದು ಹೈಕೋರ್ಟ್ ಸರ್ಕ್ಯುಲರ್ ಇದೆ ಅನ್ನೋದೇ ಗೊತ್ತಿಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಗಳಿಗೆ. ಪ್ರಬಲಿಂಗ್ ತುಂಬಿಗೆ ಅವರಿದ್ದಾರೆ ವಕೀಲರು, ಯಾಕೆ ಸುಮ್ಮನೆ ಬಿಡು ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ ಯಾರು ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅಪ್ ಟು 1 year ಅಂತಿದ್ರು ಕೂಡ 250 ರೂಪಾಯಿ ದಂಡ ಕಿಟ್ಟಿ ಹೋಗಪ್ಪ, ಡಿಫಾಲ್ಟ್ 15 ದಿವಸ ಜೈಲು ಆಗಿದೆ. ಹಣೆ ಬರ ಆಗಿದೆ. ಹಾಗಾಗಿನೇ ಹೆಚ್ಚಿನ ಇಂಥ ಅಫೆನ್ಸ್ಗಳು ನಡೀತದೆ. ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅದ ಹೆದರಿಕೆ ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ ಫೈನ್ ಆರ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅಂತ ಬಂದ್ರೆ ಅವಾಗ ಬರೀ ಫೈನಿಗೆ ಮಾತ್ರ ಕನ್ಫೈನ್ ಮಾಡ್ಬೋದು. ಮ್ಯಾಕ್ಸಿಮಮ್ ಏನು 2,000 ರೂಪಾಯಿ ದಂಡ, ಬಿಸಾಕು 2,000 ರೂಪಾಯಿ ದಂಡ. ಆ ಪರಿಸ್ಥಿತಿ ಬಂದಿದೆ. ಎಷ್ಟೋ ರಿವಿಷನ್ ಅಲ್ಲಿ ಬಂದ ಎಲ್ಲದೂ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕನ್ಕ್ಲೂಡ್ ಮಾಡ್ತಾ ಏನ್ ಹೇಳ್ತಾರೆ ಗೊತ್ತೇ ವಕೀಲರು, ಸ್ವಾಮಿ ದ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಮೇ ಬಿ ರೆಡ್ಯೂಸ್ ಟು ಅಂಡ್ ಕನ್ಫೈನ್ಡ್ ಓನ್ಲಿ ಟು ದಿ ಫೈನ್ ಅಂತ. ನಾವು ಪ್ರವೃತ್ತಿಗಳು ಕೂಡ ನೋಡ್ತೇವೆ. ತುಂಬುಗಿಯವರೇನೋ ಕೇಳ್ತಿದ್ದಾರೆ ನೋಡಿ. ಇಂಟೆನ್ಷನ್ ಬೇಡ ಇದಕ್ಕೆ. 304 ನಲ್ಲಿ ಇಂಟೆನ್ಷನ್ ಇಲ್ಲ ವಕೀಲ್ರೆ. ಕೈಂಡ್ಲಿ ಡೋಂಟ್ ರೀರೈಟ್ IPC. 304 ಏನಲ್ಲಿ ಇಂಟೆನ್ಷನ್ ಬಂದ್ರೆ ಅದು 300 ಆಗುತ್ತೆ. ದ ಓನ್ಲಿ ಡಿಫರೆನ್ಸ್. ಹಾಗಾಗಿನೇ ಇಂಟೆನ್ಷನಲಿ ಸಾಯಿಸ್ಬೇಕು ಅಂತಿರೋರು ಈ ಮರಳು ಲಾರಿ ಮಾಫಿಯಾ ಅಂತ ಏನು ಜನ ಹೇಳ್ತಾರೆ, ಮಾತಾಡ್ತಾರೆ, ಅವರು ಹೋಗಿ ಹೊಡೆದು ಚಾಕು ಹಾಕಿ ಮಾಡಲ್ಲ. ಅವ್ರ ಮೇಲೆ ಒಂದು ವೆಹಿಕಲ್ ಹತ್ತಿಸ್ತಾರೆ. ಅವಾಗ ಅದು 300ಗೆ ಬರಲ್ಲ, 304A ಗೆ ಇಳಿಯುತ್ತೆ. ತುಂಬಗಿ ಅವ್ರು ಬರ್ತಾರೆ, 1 month ಸಿಂಪಲ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅಂತಾರೆ. ಯಾವನೊಬ್ಬ ಡ್ರೈವರ್ ಹೋಗಿ ಬರ್ತಾನೆ, ಮುಗೀತು, ಕೇಸ್ ಕ್ಲೋಸ್. ನೋಡಿ ಎಷ್ಟು ಈಸಿ ಇದೆ ನಮ್ಮಲ್ಲಿ ಅಸೆಸಿಂಗ್ ದಿ ಹ್ಯೂಮನ್ ವ್ಯಾಲ್ಯೂ, ಹ್ಯೂಮನ್ ಲೈಫ್. ಹೇಳಿ. ಹಾಗಾಗಿ ಇದರಲ್ಲಿ ಇಂಟೆನ್ಷನ್ ಕ್ವಶನ್ ಇದರಲ್ಲಿ ಬರಲ್ಲ. ಎಸ್. PW1.
Complainant also. PW3 is not of the villain rider who suffered injury also. Supported the person. PW2 supported, PW3 supported, and not PW4 also not one of the eyewitness not support. PW5 not a Venkatesh is a spot merger witness not.
the exhibit B5.
He too has a portrait.
B6 is Gangadhar model ASI. Registered the model further investigation handed over to model CBI. The Caesar model. W7 is the model of the IO. Correct the statement and seal the vehicle. But the PW8 is the model Modi. Not Larry Green. But he stated not the fault of moped not extended as the model.
PW7 is IO. PW8 is
Larry Cleaner. Stated that not the moped rider was at fault. As could be gathered from the evidence of all these witnesses. But all the witnesses, not the except PW1, stated that not the they have seen the accident. But not the due to not according to me, not it might be happened not due to mechanical failure also. I will take not the evidence of PW1. June 2003 ಇಂದ June 2005 ವರೆಗೆ ನಾನು ಆರ್ಟಿಒ ಆಗಿ ಹಾಸನದಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. 24/8/2004 ಅರಸೀಕೆರೆ ಗ್ರಾಮ ವೃತ್ತ ನಿರೀಕ್ಷಕರ ಮನವಿ ಮೇರೆಗೆ ನಾನು ಅದೇ ದಿನ ಮಧ್ಯಾಹ್ನ 12:30ಕ್ಕೆ ಚಂದ್ರಾಯಪಟ್ಟಣ ಅರಸೀಕೆರೆ ರಸ್ತೆಯ ಗಂಡಸಿ ಹ್ಯಾಂಡ್ ಪೋಸ್ಟ್ ನಂಜುಂಡೇಶ್ವರ ಇಂಜಿನಿಯರಿಂಗ್ ವರ್ಕ್ಸ್ HM6512 ಅವರ ವಾಹನವನ್ನು ತಪಾಸಣೆ ಮಾಡಿದಾಗ ಕಿಕ್ಕರಂಡ ನ್ಯೂನತೆಗಳು ಕಂಡು ಬರುತ್ತವೆ. Next second of K30L8198 ರ ಮೋಟಾರ್ ವಾಹನವನ್ನು TS ಸೆಕ್ಷನ್ ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕೆಳಕಂಡ ನ್ಯೂನತೆಗಳು. Third point is very important. ಹೌಸಿಂಗ್ ಅಸೆಂಬ್ಲಿ ಸಂಪೂರ್ಣ ಜಖಂಗೊಂಡಿದ್ದರಿಂದ ಲಾರಿಯ ಬ್ರೇಕ್ ಅನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲು ಸಾಧ್ಯವಾಗಲಿಲ್ಲ. ಅಭಿಪ್ರಾಯದಲ್ಲಿ ಯಾವುದೇ ಯಾಂತ್ರಿಕ ದೋಷದಿಂದ ಆಘಾತವಾಗಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ನೋಡ್ತೀವಿ at the same time stated that he has not checked the brakes.
Do you mean to say that without inspecting the condition of the brake, the motor vehicle inspector, who is an expert in the field, cannot come to any conclusion as to whether the accident was due to any mechanical defect or not?
I will come. Road is not. He admitted that the road is so steep and not even the other witnesses also said that not the road is very not steep, and moreover not they stated that he has applied the brake also, the lorry driver. But then
Exactly.
not the lorry moved.
Yes. Even after application of the brake, if the lorry has moved further, then don't you come to a conclusion that it was in such a rash driving or it was in such a high speed, either of these two. Otherwise the lorry would have been stopped. ಆತನಿಗೆ ಲಾರಿಯನ್ನು ನಿಯಂತ್ರಣಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾರದಷ್ಟು ಸ್ಥಿತಿಯಲ್ಲಿ ವೇಗದಲ್ಲಿ ಅಥವಾ ಕ್ರಮದಲ್ಲಿ ಲಾರಿಯ ಚಾಲನೆ ಆಗುತ್ತಿದೆ. ಹೆಚ್ಚಿನದ ಹಾಗೆ ಆಗ್ತದೆ.
ಸಡನ್ ಆಗಿ ಯಾರಾದ್ರೂ ಬಂದಾಗ he suddenly applied the brake. Lorry will automatically
ಆಗ್ತದೆ. ಸಡನ್ ಆಗಿ ಬ್ರೇಕ್ ಹಾಕಿದಾಗ ಯಾರಾದ್ರೂ ಇಮಿಡಿಯೇಟ್ ಬಂದ್ರು ಲಾರಿಗೆ ಇಮಿಡಿಯೇಟ್ ಬ್ರೇಕ್ ಅಪ್ಲೈ ಮಾಡಿದ ಅಂತ ಹೇಳಿದ್ರೆ ಮೊಟ್ಟ ಮೊದಲನೇದಲ್ಲಿ ರೋಡ್ ಸ್ಕ್ರಾಚ್ ಆಗ್ತದೆ ಆಗುತ್ತೆ. ಅದು ಎಷ್ಟು ದೂರ, ಯಾವ ರೀತಿ, ಯಾವ ಆಂಗಲ್, ಯಾವ ಡಿಸೈನ್ ಹೋಗ್ತದೆ. ಆಮೇಲೆ ಬ್ರೇಕ್ ಡ್ರಮ್ ಕೆಲವುದರಲ್ಲಿ ಬರ್ಸ್ಟ್ ಆಗ್ತದೆ, ಕೆಲವುದರಲ್ಲಿ ಲಾಕ್ ಆಗುತ್ತೆ. ಲಾರಿ ಒಂದೋ ಬೀಳುತ್ತೆ, ಟರ್ಟಲ್ ಆಗುತ್ತೆ, ತಿರುಗಿ ನಿಲ್ಲುತ್ತೆ ಅಥವಾ ಸೊಟ್ಟ ಹೋಗುತ್ತೆ. ಇದಿಷ್ಟು ಸಾಧ್ಯತೆ ಇದೆ. ಅದು ಲಾರಿಯ ವೆಯ್ಟು, ಲೋಡು, ಸ್ಪೀಡು, ರೋಡ್ ಕಂಡೀಷನ್ನು, ಟೈರ್ ಕಂಡೀಷನ್ ಇಷ್ಟು ಇರ್ತದೆ ಅಲ್ವೇ? ಸೊ ಮೋಟರ್ ವೆಹಿಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಗೊತ್ತಿರಲು ಚೂರು ನಂಗೂ ಗೊತ್ತಿದೆ. ಹೇಳಿ ಮುಂದೇನು?
ಸದರಿ ಟ್ಯಾಂಕರ್ ಭಾರಿ ಸರಕು ವಾಹನ ಅಂದ್ರೆ ನಿಜ. ಸದರಿ ವಾಹನಕ್ಕೆ ಎಕ್ಸಿಲ್ ವಾಹನದ ಹಿಂಭಾಗದಲ್ಲಿ ಭಾರಿ ಸರಕು ವಾಹನ ಸರಕು ತುಂಬಿದ್ದ ಪಕ್ಷದಲ್ಲಿ ಅದು ಇಳಿಜಾರಿನಲ್ಲಿ ಬರುವಾಗ ಯಾವುದಾದ್ರೂ ಗುಂಡಿಗೆ ಬಿದ್ದಲ್ಲಿ ಅದರ ಬ್ರೇಕ್ ಎಕ್ಸೆಲ್ ಅಸೆಂಬ್ಲಿ ಹಾಳಾಗುವ ಸಾಧ್ಯತೆ ಇದೆ. ಅಥವಾ ವಾಹನ ಇಳಿಜಾರಿನಲ್ಲಿ ಬರುವಾಗ ತಕ್ಷಣ ಬ್ರೇಕ್ ಹಾಕಿದಲ್ಲಿ ವಾಹನದ ಒಂದು ಭಾಗಕ್ಕೆ ಮುಗಿಸಿಕೊಂಡ ಸಮಯದಲ್ಲಿ ಆಕ್ಸಿಲ್ ಅಸೆಂಬ್ಲಿ ಹಾಗೆ ಇರುತ್ತದೆ. ಅದಕ್ಕೆ ಯಾವುದೇ ಜಖಂ ಆಗುವುದಿಲ್ಲ. ನಂತರ ಸಮಯದಲ್ಲಿ ಸದರಿ ವಾಹನ ಉಳಿದಾಗ ಎಕ್ಸೆಲ್ ಸಿಸ್ಟಮ್ಗೆ ಜಖಂ ಆಗುವ ಸಾಧ್ಯತೆ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್, ಟ್ಯಾಂಕಿನ ಒಳಗಡೆ ಯಾವುದೇ ವಸ್ತುವನ್ನು ನಾನು ತಪಾಸಣೆ ಮಾಡಿದಾಗ ಇರಲಿಲ್ಲ. ಒಳಗಿಂದೇನು ಇವರು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿಲ್ಲ.
ಒಳಗಿಂದೇನು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ, ಅದು ವಕೀಲರು ಓದೋದು.
ಟ್ಯಾಂಕಿನ
ಕೋರ್ಟ್ ಓದೋದನ್ನ ಓದ್ತೇನೆ ಕೇಳಿ. ಟ್ಯಾಂಕ್ ನ ಒಳಗೆ ಯಾವುದೇ ವಸ್ತುವನ್ನು ನಾನು ತಪಾಸಣೆ ಮಾಡಿದಾಗ ಇರಲಿಲ್ಲ. ಇದು ಕೋರ್ಟ್ ಓದೋದು. ಕೋರ್ಟ್ ಯಾವತ್ತು ಹೆಂಗಿರುತ್ತೆ ಹಂಗ ಓದುತ್ತೆ. ಮುಂದೆ
ನಂತರ ಸಮಯದಲ್ಲಿ ಟ್ಯಾಂಕರ್ನ ಎರಡೂ ಕಡೆ ಜಖಂ ಆಗುವ ಸಾಧ್ಯತೆ ಇದೆ. ನಾನು ತಪಾಸಣೆ ಮಾಡುವ ಸಮಯದಲ್ಲಿ ಸದರಿ ವಾಹನ ರಸ್ತೆಗೆ ಓಡಾಡುವ ಸ್ಥಿತಿಯಲ್ಲಿ ಇದೆ. ವಾಹನವನ್ನು ರಸ್ತೆಗೆ ಚಲಾಯಿಸಿ ನೋಡದೆ ಅದರ ಬ್ರೇಕ್ ಸರಿಯಾಗಿದೆ ಇರುವುದನ್ನು ನನಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ ಅಂದರೆ ಸ್ಥಿತಿ supported the lot of the prosecution, but not take note of page number 2. What is our next page?
1 minute. Yes.
Seen from not of the evidence of not of the PW1. Failure of not of the brake system. Cannot be not.
He has not stated failure of brake system. He has stated that due to the condition of the vehicle, brake could not be examined.
My submission that could be seen from his evidence. There may be a chances of not of the failure of not. There might be a chance of not of the.
Sir, if that were to be the case, PW1 was expert than you. He would have definitely stated, both in his oral evidence as in MV report, or at least you could have specifically asked him whether your report clearly denotes that there is failure of brake system. You would have said yes or no. If you have said yes, then you would have been in position. And furthermore, for your kind information, mere a failure of brake system also not necessarily in all cases absolve the driver from 279. Right? The failure of brake system as a defense is applicable only in certain circumstances of cases. ಹೌದು ಯಾಕೆಂದ್ರೆ ಆ ಪಾರ್ಟಿ ಹೋಗಿದೆ 52 ಫೀಟ್ ಹೋಗಿದೆ ಮುಜ್ಗಂಡು ರಸ್ತೆ ಹೋಗಿ ಉಲ್ಟಾ ಬಿದ್ದಿದೆ ಲಾರಿ.
He supported the not the prosecution. He complained. Let not the portion my lordship permits.
From PW2, we will continue from PW2 to more. Learned interest for the petitioner, learned SCGP for the respondent of physically present. For the argument of learned amicus curiae for the petitioner in part. Since the court time is over, list this matter on the top of the list. Knowledge date. And there is knowledge date file consequently immediate.
Number 48, Rajshekhar.
None appear. This matter on 2010. It is made clear that no further adjournment will be granted. It is revision petition of the year 2013. Yes.
Say number 40. Number 49, Kalyanar. Sri Ravi Kumar MS.
Learned counsel from both side persons. Since the court time is over, this matter on 2010. No, any change in the name to be shown in the cause list, we first consult there in the registry. If they don't do, then we will pass a judicial order.
50 R. Gopal,
I appear for
Sri
the
Sridhar Negre.
petitioner in this case, Lord, I'm ready for petitioner. 138, Lord. Two cases are there.
The counsel for the petitioner is appearing through video conference. Who appears for respondent? Your correspondent. The counsel for the respondent is physically present. Since the court time is over, it's the matter in the next week.
Lord, may I submit, Lord?
21, 25, 27. Which date you want?
20.
21, Mr. Counsel.
Yes, my Lord, yes. 21, no, my Lord, 20th, your Lordship, have it, my Lord.
Yes, Lord.
20th.
20, 10.
20th, my Lord.
Bless you.
My Lord, one submission, my Lord. I have prepared a synopsis, my Lord, and one list of authorities, my Lord. I need permitted to place, my Lord. My colleague is there, my Lord. He will place it on record. It may be taken on record, my Lord. Yes.
No, the authorities would be taken provided you relay them on in your argument.
Yes,
the
my Lord, I will
synopsis
do it.
only if necessity arises, we will have it. Otherwise, we won't.
But it may be necessary, my Lord. That's why.
No, if necessity arises, we will do that. Say, I extract more details than what would be there in the synopsis
Yes,
of the
sir.
argument.
Sometimes
Your colleague can say, leave it here.
Yes.
But taking the same on record would be only after hearing you.
Yes.
You can delete file and sorry. Good.
Bless you.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ ಸರ್.
ಸ್ವಲ್ಪ ನಾನು ಅಪಿಯರ್ ಆಗಿ ಲೇಟ್ ಆಯ್ತಾ?
ಇಲ್ಲ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ನೀವು ಕೇಳಿದಷ್ಟೇ ಹಾಗೆ
ಅಷ್ಟೇ ಆಗ್ಲಿ ಸರ್, ಆಗ್ಲಿ. ಥ್ಯಾಂಕ್ ಯು.